Okay.
Good afternoon, ladies and gentlemen. Welcome to Bexar County County Court at Law number 6 and the Bexar County Veterans Treatment Court plea and motion to revoke probation docket for Wednesday afternoon, September 1. I apologize for the delays, but we're getting documents late and it slows us down. The first two issues I have on our Veterans Treatment Court cases, cause number 650310, State of Texas versus Dustin Wiggins, represented by Miss Ashley Morgan. And my record reflects that the actual plea, which at the time we thought was going to be a Bexar County Veterans Treatment Court Track 2 deferred adjudication plea, was entered on August 17th, 2021. Josh, is that correct?
That is correct, sir.
Okay. At that time, the staff of the Veterans Treatment Court, nor Miss Morgan, were aware that Mr. Wiggins had taken a wonderful job opportunity with the Department of Defense, which the Veterans Treatment Court certainly supports him in, but it made him ineligible to actually be in the Veterans Treatment Court. Since the basic elements of a plea, whether in the Veterans Treatment Court or in a standard county court at law number 6 trial court plea, are going to be exactly the same. So what I spoke to Ms. Morgan and the DAs about at that time was that we were going to convert Mr. Wiggins' plea into the Veterans Treatment Court into a plea into the regular county court at law number 6 trial court docket as a deferred adjudication, exactly as it was represented. The only variation on that theme was it had to take away the $1,000 all-inclusive Veteran Treatment Court fee and made that a $500 fine plus court cost. Is that acceptable, Ms. Morgan?
Yes, Judge. He actually did sign the plea agreement and has already made payments towards that plea agreement.
Okay.
Requested by the court.
Anyway, we're just making it clear for everyone that that's what we're doing. This is not a Bexar County Veterans Treatment Court plea, even though at the time it was everyone's intention to do so. Is there any objection from the defense on moving Mr. Wiggins into the basic deferred adjudication probation docket in County Court 6 instead of the Veterans Treatment Court?
No, Judge. I believe he's already gone over his terms and signed those conditions.
Perfect. And we've been in contact with Mr. Wiggins. He's already gotten a Smart Start mobile device. Let me just go through this real quick. My understanding of Mr. Wiggins' conditions in County Court of Law number 6 are going to be basically the same as we originally anticipated. The case was originally a driving while intoxicated greater than 0.15 blood or breath case. The state waived the enhancement. Mr. Wiggins pled guilty to the charge of driving while intoxicated. First offense was granted 1 year deferred adjudication probation, $500 fine plus court costs, 48 hours community service, probating all that based on his military service, DWI Victim Impact Panel, DWI Education, Community Alliance for Traffic Safety New Intervention Program, which is our outpatient drug program, or an equivalent. If Mr. Wiggins is out of town and can't come to that course, Ms. Morgan, you and the state and I can come up with an equivalent outpatient drug course wherever he is. It's not a problem. And he's already active on a Smart Start mobile at 4 blows a day, and he'll do that for 6 months. Did Mr. Wiggins get proactive credit for any of these cases like most of your clients normally do?
Mr. Wiggins, I can't remember. Did you do your classes?
Okay.
I have not yet.
Okay. If Mr. Wiggins or any other defendant does stuff proactively, we're certainly give him credit for it. So just provide that to your probation officer. You have any questions, Mr. Wiggins?
No, Your Honor.
All right. Thanks for your service, sir. Best of luck. If we can help you in any way, let us know.
Thank
Thanks
you.
a lot, sir. Appreciate
Ms.
it.
Morgan, anything further?
No, sir.
You're excused. Thank y'all for coming. Okay, the next case we have is another Bexar County Veterans Treatment Court case called 621736, State of Texas versus Patricia L. Blackwell. We had a previous hearing on this case, at which time one of the attorneys was called away to an emergency Zoom hearing and we couldn't finish it. This basically is the state's notice of termination of pretrial intervention on Ms. Blackwell's case 621736. Based on a variety of issues that I'm sure Ms. Blackwell also has her side, but it involved just her inability to successfully complete the requirements of the Veterans Treatment Court to a great degree because she has some severe medical problems which stop her from participating fully in the Veterans Treatment Court. But there were myriad skips on the Smart Start mobile device, various skips on calling the UA hotline, and various and sundry other issues that came up through the course of her probation. It just made it where she could not successfully complete the Veterans Treatment Court. So at this time, and we have Judge Joanne here?
Yes, Your Honor.
Okay.
And for the record, you had asked me to talk to my client in the breakout room, and I couldn't do it at that moment. So we've had an opportunity to talk since our last hearing. She's accepting that she will be removed from the BTC program, and she's aware of that.
Okay, well, Ms. Blackwell, we all think that's in your best interest. But what's going to happen at this point is I'm going to grant the state's notice of termination of pretrial intervention. And I'm going to accept Ms. Blackwell's plea of guilty to the offense of driving while intoxicated with a blood or breath alcohol content greater than 0.15, accepted originally on November 13th, 2020, and find her guilty of the offense of driving while intoxicated with a blood or breath alcohol content greater than 0.15. How many days of jail credit does Ms. Blackwell have? Does anybody know?
I'm on the phone right now.
State, do you have a recommendation on sentencing?
Yes, Your Honor. The state recommends a $600 fine. My understanding is that Ms. Blackwell paid $600, so that can be satisfied. Court costs, 1 year Bexar County Jail, probated for 9 months, 48 hours of community service. Those should be probated as well, Judge, because of the military service. DWI education, VIP live, VA treatment, and that's instead of the CAT-SNP program. Smart Start mobile device for half the term, and the state's okay. The state has no objection if Ms. Blackwell gets credit for everything that she did while she was in the BTC program.
Okay, Judge DeHoyle, do you have a request?
Yes, Your Honor. We're asking for JSAT, as we had informed with the staffing that for her to apply for probation would cause a lot of paperwork and wouldn't be able to done. She's had 1 day in and she's paid. She's done her programs. So in effect, she's already done probation. So we're asking for a JSAT.
How much jail time does Ms. Blackwell have on this case? Does anybody, is it 1 day or is it more than that?
It was
It's
1
only
day.
1 day.
Ms. Blackwell, the court accepts your plea of guilty to the offense of DWI greater than 0.15, originally rendered and held in abeyance back on November 13, 2020. I find you guilty of the offense of driving while intoxicated with a blood or breath alcohol content greater than 0.15. I sentence you to 3 days in the Bexar County Jail, a $1,000 fine plus court costs, credit for time served, time and money to run concurrent, judgment satisfied. Anything further from the state of the defense on Ms. Blackwell?
No, Your Honor.
Good luck, Ms. Blackwell. Thank you for your service, ma'am. Best of luck. And thank you, Judge Joanne. You're excused at this time.
Thank you. Bye. Thanks, Josh.
Thank you, ma'am.
Okay, we did that one. We're going to have a fun and exciting afternoon. We have lots and lots of cases. Did we get our interpreter situation squared away, or is that still a problem?
I just left the breakout room. I believe the interpreter is trying to fix audio issues on a different client.
But it's not yet repaired. Is that your understanding, Joseph?
Some of them are fixed. So Henry Castaneda for Joanne de Hoyos, his audio is fixed. I don't know about the others.
And Flores Zelaya, I believe, was fixed as well.
Pat, are you on with us today?
I think she went to a breakout room.
Yeah, I think she's in a breakout, Judge.
Okay, I think we need her to coordinate all this, do we not?
Correct.
All right, well, let's start doing some regular pleas. When we get Pat back, we'll jump to the Spanish pleas if that is available at that time. Stand by, let me get coordinated here. Have we got Mr. Chumbley and Ms. Padilla?
Yes, sir, we're here.
Hot damn. Stand by.
Your Honor, we're back.
Yes, I'm
The
here.
interpreter's
Honor.
back. Some of the people are able to connect. We're having trouble with one of them, which is Daniel Garcia. The interpreter, there is no audio for him. They aren't hearing it. I don't know whether, I believe Joseph Statson and Castaneda did go in. I think they were able, whether here in the main gallery they're able to, I do know. Mr. McCrum and his defendant also went in, spoke with the interpreter, were able to connect. but I'm not quite sure yet what's happening here. So we still need one more individual. And that is Alan Beltran. There was an issue there, but I don't know whether they were able to connect or not because he went in and out.
He's here. He's in the main lobby,
Okay,
Ms. Benavides.
okay.
He was able to get connection.
He was able to connect with the interpreter?
We're here in the main room. He was able to reconnect. His device got turned off. So if
Okay.
you want to to the breakout room again.
So Judge, how do you want to do this?
Okay, well, I'm still confused. You're saying the interpreter works okay on some cases, but doesn't work okay on other cases?
Yes, they're trying to set up on those other cases. Some
All
of
right.
them I believe they can.
Let's do this. Let me start doing normal English,
Yes.
please, until such time as hopefully you've been able to establish that the interpreter
Exactly.
is viable on all Spanish cases, okay?
Of course, of course.
I apologize to those attorneys what we're doing, but that's what we're doing.
Okay.
All right, so batting order coming up.
All right. Mr. Sandoval, I'm going to put you in a breakout room.
Okay, back on the record, call 660-643, State of Texas versus Carmen Padilla, and Mr. Chumley representing. Dwight, are you ready on this case?
Yes, I am, Your Honor.
Thank you. Stand by. Call 654-4421, State of Texas versus Gustavo A. Zavala. Tim Roundtree, attorney. Tim, are you ready on this one?
We're ready, Judge.
Thank you. Call 629957, State of Texas versus Michael A. Ribiezo. Stephen Reynolds, are you ready on this one?
Ready, Judge.
Okay, and I got 664141, State of Texas versus Orlando Laredo, also with Mr. Reynolds.
Yes, Judge, we're ready.
Call 645300, State of Texas versus Christopher M. Trevino with John Fox. John with us today?
Yes, Your Honor, we're ready.
All right, thanks. Call 659538, State of Texas versus Leah Flores, or maybe it's Lee Flores, John Garcia.
Yes, we're ready, Your Honor.
Okay.
We are ready.
So that's our batting order. Okay. At this time, I need each of the defendants and attorneys to identify their signature on a document entitled Defendant's Consent to Plea by Video Conference. And cause 660-643, Ms. Padilla, is this your signature on this document, ma'am?
Yes, Your Honor.
And Mr. Chumley, as attorney for Ms. Padilla, is this your signature on this document?
Yes.
Thank you. And call 654-421, Mr. Zavala, is this your signature on this document?
Yes.
Thank you, sir. And Mr. Roundtree, as attorney for Mr. Zavala, is this your signature on this document?
Yes, Your Honor.
Thank you. And call 629957, Mr. Ribiezo, is this your signature on this document?
Yes, Your Honor.
Thank you. And Mr. Reynolds, as attorney for Mr. Ribiezo, is this your signature on this document?
Yes, Judge.
Thank you. And call 664141, Mr. Laredo, is this your signature on this document?
Yes, sir.
And Mr. Reynolds, as attorney for Mr. Laredo, is this your signature on this document also?
Yes, Judge.
Thank you. And call 645300, Mr. Trevino, is this your signature on this document?
Yes, Your Honor.
Thank you. And Mr. Fox, as attorney for Mr. Trevino, is this your signature on this document?
It is, Your Honor.
Thank you. And call 659538, Mr. Flores, or Ms. Flores, is this your signature on this document?
Yes, sir.
Thank you. And Mr. Garcia, as attorney for Ms. Flores, is this your signature on this document?
It is, Your Honor.
The next document I have is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions, that purports to have your signature on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Ms. Padilla, is this your signature on this document also?
Yes, Your Honor.
Thank you. And Mr. Zavala, is this your signature on this document?
Yes, Your Honor.
Thank you. And Mr. Ribiezo, is this your signature on this document?
Yes, Your Honor.
Mr. Laredo, is this your signature on this document?
Yes, sir.
And Mr. Trevino, is this your signature on this document?
Yes, Your Honor.
And Ms. Flores, is this your signature on this document?
Yes, sir.
Thank you. By signing this document, are each of you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney. So that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, Ms. Padilla?
And you're talking about the plea bargain document,
This
sir?
is defendant's waiver of constitutional rights and court's admonitions. You have to agree to this document before you can enter a plea before the court. And then if your attorney has a plea bargain with the state, that will certainly be followed.
Judge, the title on that document, it says she's pleading guilty to DWI and she's pleading guilty to obstruction of a highway.
We'll fix that.
Okay. Other than that, that's the only change that we see needed.
Okay. So Ms. Padilla, are you in agreement with my last statement?
Yes, Your Honor.
Thank you. Mr. Zavala, is that correct?
Yes, Your Honor.
Thank you. Mr. Riviezo, is that correct?
And Judge, on his case, it's the same thing as Mr. Chumbley's. It's originally a DWI, but this is going to be an obstruction plea.
Not a problem, and we'll take that up at the appropriate time. Bring it up to me when we get into the actual plea aspect of this thing. But a lot of people have it that way, so I apologize it's that way, but it is. But we'll fix it. Okay, Mr. Laredo, do you agree with that?
Yes, sir.
All right, thank you. And Mr. Trevino, are you in agreement with that?
Yes, Your Honor.
Thank you. And Ms. Flores, are you in agreement with that?
Yes, sir.
Thank you. As attorney for Ms. Padilla, Mr. Tremblay, have you had enough time to go over this case with her? And in your opinion, is she mentally competent?
She is, Your Honor.
Same question for attorney for Mr. Zavala, Mr. Roundtree.
Yes, Judge.
Same question for attorney for Mr. Riviezo, Mr. Reynolds.
Yes, Judge.
Same question for attorney for Mr. Laredo, Mr. Reynolds.
Yes, Judge.
Same question for attorney for Mr. Trevino, Mr. Fox.
Yes, I have, and he is, Your Honor.
Same question for attorney for Ms. Flores, Mr. Garcia. John, are you with us?
Yes, Your Honor, she is.
All right, thanks. Ms. Padilla, are you a United States citizen, ma'am?
Yes, sir.
Thank you. Mr. Zavala, same question.
Yes, Your Honor.
Thank you. Mr. Riviezo, same question.
Yes, Your Honor.
Thank you. Mr. Laredo, same question.
Yes, sir.
Thank you. Mr. Trevino, same question.
Yes, Your Honor.
Thank you. And Ms. Flores, same question.
Yes, sir.
Mr. Chumbley, as attorney for Ms. Padilla, has the state fully complied with discovery for you on this case?
Yes, sir, they have.
Thank you. Same question for Mr. Roundtree, as attorney for Mr. Zavala.
Yes, Your Honor.
Thank you. Same question for Mr. Reynolds, as attorney for Mr. Riviezo.
Yes, Judge.
Thank you. Same question for Mr. Reynolds, as attorney for Mr. Laredo.
Yes, Judge.
Thank you. Same question for Mr. Fox, as attorney for Mr. Trevino.
Yes, Your Honor.
Thank you. And same question for Mr. Garcia, as attorney for Ms. Flores.
Yes, Your Honor.
Thank you. Okay, let's see what I got here on my plea document stuff. And State, do you have a motion on Ms. Padilla's case?
Yes, Your Honor, the state moves to amend the information and to include a count, obstruction of a highway count, and waive count number one, which is the DWI charge.
Is there already an obstruction paragraph, or are we adding an obstruction paragraph?
We're adding an obstruction paragraph.
No objections, Judge.
Hang on, we'll get there. Thank you, though.
Excuse me,
Who's talking, please?
Judge. This
Yeah.
is Carmen Padilla.
Yes, ma'am.
I wanted to say that, I'm pleading guilty for DUI, but my plea bargain is the obstruction of highway.
Yes, ma'am. We're going to get there. Don't worry about it. It's all good. Your attorney will take good care of you. All right, state's motion to amend the information and add paragraph 2 alleging obstruction of a highway, no objection from the defense is granted. State then waiving paragraph 1 and proceeding on paragraph 2, obstruction of a highway is granted. Therefore, Ms. Padilla, to the charge of obstruction of a highway, how do you plead, ma'am?
For guilty.
All right, thank you. Is there an agreement for Ms. Padilla?
Yes, Your Honor. $850 fine, court costs, 16 months deferred adjudication, 48 hours of community service, DWI education, VIP, CAT SNP, Smart Start mobile device for half the term, anger management course, and pay restitution to DPS in the amount of $60, and that is for the lab.
It's actually reimbursement, it's not restitution, but it'll all work out. All right, and Mr. Chumley, is that your understanding of the agreement?
It is. I would like to make a slight plea to reduce the amount of probation time. This case involved Ms. Benavides being asleep in a parking lot in her car. There was no driving accident or anything, but more importantly, she has begun attending outpatient program with Rise Recovery on a weekly basis. She did that on her own accord. She's also finished up a divorce that kind of sent her into a spiral, and she's taken ownership of her situation. And we would appreciate if we could ask for a little less time of probation so that, she can get on down the road.
Okay, well, that all needs to be worked out as a plea bargain in advance of trial. But since you brought it up, State, you have an objection to that?
I haven't started.
Go ahead.
Judge, I wasn't aware this was an open plea. I leave that up to the court's discretion, Judge.
Ms. Padilla, do you have any prior offenses?
No, Your Honor.
Okay, Ms. Padilla, the court accepts your plea of guilty to obstruction of a highway. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt, place you on 1 year deferred adjudication, assess a $850 fine plus court cost, 48 hours community service, DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, Smart Start mobile home interlock at 4 blows a day for half the term or 6 months, a PSC anger management course, pay reimbursement to the Texas Department of Public Safety in the amount of $60 for a blood test, I'm guessing. Anything further from the state of the defense on Ms. Padilla?
No, Your Honor.
Good luck, Ms. Padilla. Thank you, Mr. Chumley.
Thank you.
Thank you.
Yeah. Hang on. Let's keep going. Okay, and cause 654-421. State, you got another motion on this one, it would appear.
Yes, Your Honor. That's regarding Mr. Zavala, right?
Yes.
This is, Gustavo Zavala.
Yes, the state moves. Yes, Judge, the state moves to amend the information to include paragraph 2, which should be an obstruction of a highway paragraph, and to waive and abandon paragraph number 1, which is the DWI paragraph.
Okay, stand by. State's motion to amend the information and add a paragraph 2 alleging obstruction of the highway. No objection from the defense is granted. Then state's motion to waive paragraph 1 and proceed on paragraph 2, obstruction of a highway, once again, is granted. Therefore, Mr. Zavala, on cause 654-421, to the charge of obstruction of a highway, how do you plead, sir?
Guilty, Your Honor.
Is there an agreement for Mr. Zavala?
Yes, Your Honor. 14 months deferred adjudication, $750 fine, court cost, 24 hours of community service, DWI education, VIP, CAT SNP program, and the Smart Start mobile device for half the term.
And defense, is that your understanding of the agreement?
It is, Your Honor.
Mr. Zavala, on cause 654-421, the court accepts your plea of guilty to the offense of obstruction of a highway. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt. Put you on 14 months deferred adjudication probation. Assess a $750 fine plus court costs. 24 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety new intervention program, and Smart Start mobile home interlock at 4 blows a day for 7 months. And on all these cases, we're going to waive any pretrial conditions. Any of those bad things I probably did to your client on pretrial will all come off, and they'll just be on probation. Anything further from the state of the defense on Mr. Zavala?
No, Your Honor.
Judge, Mr. Zavala works out of county. We'd ask that you'd grant him permission to travel outside of Bexar County for work.
What does he do and where is he going?
San Marcos, and I don't remember. Gus, what do you do for a living?
Yes, so I'm a reliability maintenance engineer for Amazon at SAT2.
Amazon, the Amazon that gets all my money constantly, that Amazon? Do you need to go just to San Marcos or to other places? What's going on with that?
San Marcos, but I do travel sometimes for training outside of the state.
All right, we'll get specific permission for those. You're going to have my permission to travel anywhere in the state of Texas without getting permission from your probation officer. But if you need to go overnight out of state somewhere, then you're going to need to ask for permission. Fair enough?
Thank you, Your Honor.
Thank you, Judge.
And we're good. All right. Thank you, Mr. Zavala. Thank you, Mr. Roundtree. Order dismissed.
Your Honor, maybe I missed it. Is probation going to contact him?
Good question. Is Susan with us this afternoon? Is Ms. Gross with us?
Yes, Judge, I'm here.
Go ahead and give us that wonderful briefing of all the defendants on how they can get contacted by probation.
Yes, Your Honor. You will be contacted within the next 48 hours by probation, usually via email, sometimes during text. You will be told when you need to report for your orientation. If you fail to report to that orientation, the judge will issue a warrant for your arrest. So it's your responsibility to follow up. If you do not hear from anyone by Monday at noon, then you need to call the intake desk at 210-335-7446. Okay. And also, Judge, on that last case in regards to travel, the defendant needs to advise his probation officer every time he's going to travel so he can get a travel permit, but he needs to obtain permission from you for out of state, because if he's caught without a travel permit, that could create some consequences.
He won't need a travel permit if he's traveling in Texas with my permission, correct?
No, every time he travels, he has to have a paper regardless of where he goes outside of Bexar County.
All right, well, that's not the law. That may be your policy, but he's got my permission to travel in Texas. It causes more work for your people and more work for the defendant. And we've been doing it for 20 years. So why would we change now?
No, Judge, it's always been this way. They have to have a piece of paper to leave Bexar County. You can give them blanket permission to travel, but they still have to advise their officer so their officer knows where they're at.
Okay, Mr. Roundtree, you still with us?
I am, Judge.
Do that lawyer stuff. Your client has my permission to go. He doesn't need a travel permit from my understanding, although I'm sure the probation department has a requirement for it. So over to you on whatever you want to do. Susan said you have to have it or you'll get in trouble, but then guess where that goes? Right back to me. So what can I say?
And Judge, you made a note on the file that he has permission.
That's correct. That will be on his conditions.
Thank you.
About leaving the state.
All right, so we good on Mr. Riviezo?
I'm here.
Mr. Riviezo, if you get picked up and go to jail because you don't have a travel permit, call your lawyer. He'll call me. Okay?
Okay.
Judge, I think that's the wrong
Zavala.
call.
Mention that about mom.
My mother is kind of on her
Zavala.
deathbed, sir, Your Honor. And if I had permission to go see her, like, how do I go about that?
Like she's really sick.
Mr. Revisio, he wasn't talking to you on that one.
No,
Okay,
I'm sorry, I missed.
He said my name before that, but yeah.
I did. I apologize. Okay, we were talking about who was the last defendant that needed to travel to San Marcos? Mr.
Sandoval, I need you in the breakout room.
Mr. Zavala.
Okay.
All right. Tim, feel free to chat with the probation department and see if y'all can come up with a plan. That's never been brought up to me before. Okay, let's talk about Mr. Riviezo. State, you got a motion on this case, it appears.
Yes, sir.
Yes, Your Honor. The state moves to amend the information to include an obstruction paragraph, waive and abandon paragraph 1, which is the DWI charge, and proceed on paragraph 2, obstruction.
Hang on, a lot of writing. And state, just so everybody's on the same sheet of music, what I suggest to you is you make one motion that says that you want to amend the information and add paragraph 2, and then when that's granted, then we have a paragraph 2. Then you can waive paragraph 1. If you have some, kind of sharp cookie or lawyer like Eric Reynolds, he's going to come along and say, "Oh, they waived all the paragraphs. We don't have anything pending. Sorry, we're out of here." So that is what it is. Okay, no objection from the defense. State's motion to amend the information, adding paragraph 2, alleging obstruction of a highway is granted. Then, no objection from the defense. State's motion to waive paragraph 1 and proceed on paragraph 2, obstruction of a highway is granted. Therefore, Mr. Riviezo, on clause 629957 to the charge of obstruction of a highway. How do you plead, sir?
Guilty, sir.
My paperwork says no contest. State, do you care? I don't care.
That's fine, Judge.
Do you want to do no contest, Stephen, or guilty?
Do no contest, Judge.
All right, court attests plea no contest, the obstruction of a highway. Is there an agreement for Mr. Riviezo?
Yes, Your Honor. There is a $500 fine, court costs, 6 months Bexar County Jail, probated for 14 months, 48 hours of community service, DWI education, VIP, CAT SNP, Smart Start mobile device for half the term, and pay $60 to DPS for the lab.
Engineer on Social Security. It's your turn.
And Mr. Reynolds, is that your understanding of the agreement?
It is, Judge.
Okay, Mr. Riviezo, in cause 629957, the court accepts your plea of no contest to the offense of obstruction of a highway. I find you guilty. I assess 6 months in the Bexar County Jail, probated for 14 months. A $500 fine plus court costs, 48 hours community CWI Victim Impact Panel, Community Alliance for Traffic Safety New Intervention Program, Smart Start Mobile Home Interlock at 4 blows a day for 7 months, which is 1/2 the term, and reimbursement to the Texas Department of Public Safety in the amount of $60. Anything further from the state of the defense of Mr. Riviezo?
No, Judge.
Your Honor, I'm on Social Security disability, and I take medications too, and I pay $500 rent here and all the other bills. I mean, is there anything you can do for me? It's like I don't understand all these other things. I heard there was going to be a fine, but now going to these classes and all that stuff, I don't understand that.
Stephen, do me a favor and go in a breakout room with Mr. Riviezo and y'all chat about this. And if you want to withdraw his plea over, come back and do that.
That's great, Judge. Sounds
all
good.
Right. No sweat, Mr. Riviezo. Stand by. Y'all going to go chat about it and let me know what you want to do. I'm going to skip your next case, Stephen, and come back when you get back. Okay, clause 645300, State of Texas versus Christopher M. Trevino. And let's see what we're doing here. State, you got a motion on this one too, it would appear.
Just make sure you're muted. So you don't hear them. Are you muted?
State, we're on 645300, Christopher Trevino. Currently DWI greater than 0.15, but apparently you're waiving that enhanced you're doing.
I think it's Miss
So, Jack-
Galloway, Your Honor. She's trying to speak, but there's no audio.
Ms. Galloway, we can't hear you.
Which DA am I talking to? Oh, I see Megan talking, but we can't hear. Megan, we can't hear you, even though I see that your microphone is not turned off. So Houston, we have a problem.
I can do the plea in the meantime, Judge.
Go ahead.
Is Megan in a different location than you, Guillermo?
Yes.
Okay. I guess you're gonna have to talk unless Megan can fix her mic. Megan, you may want to sign out and sign back in and see if that fixes it. So Guillermo, do you know the terms of the plea bargain?
Yes, Judge. The state moves to waive the enhancement paragraph and proceed with a Class B DWI.
Okay, so basically it becomes a DWI first. Therefore, Mr. Trevino in class 645300 to the charge of driving while intoxicated, first offense, how do you plead, sir?
Guilty, sir.
Is there an agreement for Mr. Trevino?
Yes, Your Honor. $750 fine, 15 months deferred adjudication, court cost, 48 hours of community service, DWI education, VIP, CAT SNP, Smart Start mobile device for half the term, complete a gun safety course, forfeiture of the weapon to the district attorney's office, and that's regarding case number 645301, which is a UCW case. And we also asked the court to TIC that case as well.
All right, hang on, doing some serious writing here. Mr. Fox, instead of us destroying this weapon, do you want this thing? I don't know what, I'm guessing, what is it?
Yeah, so it's a little, I think it's a little 22 target pistol that I don't think anybody's really interested in. If you,
Mr. Trevino, what kind of gun is this? I know it's a pistol, but what other?
22 caliber revolver.
Who made it?
Ruger.
It's worth several $100s probably. Ms. Fox, do you want this thing instead of destroying it?
if you're disposed to do that, Your Honor, that'd be fine.
And Mr. Trevino, is that okay with you instead of destroying it?
Yes, yes, Your Honor.
I'll bring you an order, Judge.
All right, let's make sure I get this straight. Mr. Trevino on class 645300. The court accepts your plea of guilty to the offense of driving while intoxicated, first offense. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt. Place you on 15 months deferred adjudication probation. Assess a $750 fine plus court cost. 48 hours community service, DWI education, impact panel, Community Alliance for Traffic Safety New Intervention Program, Smart Start Mobile Home Interlock at 4 blows a day for 1/2 the term, which is 7.5 months. Firearm safety course. Taking into consideration clause 645301, which is granted, it shall be dismissed. Weapon awarded to, or state's motion to destroy or forfeit weapon is respectfully denied. Weapon awarded to defense counsel as additional attorney's fees with the understanding it's not to be returned to the defendant, his family, or his friend. Anything further from the state or the defense on Mr. Trevino?
No, Judge.
Good luck, Mr. Trevino. Thank you, Mr. Fox.
All right, thank you. Are we dismissed, Your Honor?
Yes, you are.
Thank you.
Thank you.
Okay, so doing that one, doing that one. Fred, let's see what we're doing with you. State, you got a motion on this one too.
Your Honor, can you hear me now?
Yeah, we got you. 5-5.
Okay, this is for Leah Flores, correct?
Go ahead.
Yes, the state moves to amend the information to include paragraph 2, an instruction of obstruction of highway.
No objection from the defense, that will be granted.
And Your Honor, the state moves to waive and abandon paragraph 1, which is a DWI paragraph, and proceed on the obstruction paragraph.
No objection from the defense, that will be granted. Therefore, Ms. Flores, in cause 659-538, the charge of obstruction of a highway, how do you plead, ma'am?
Guilty.
Paperwork says no contest. I don't think it matters to the state. It doesn't matter to me. You want to do no contest or guilty?
No contest.
Garcia? No contest.
No contest, Your Honor.
Court accepts plea of no contest to obstruction of a highway. Let's see, is there an agreement after that?
There is, Your Honor. It is for an $850 fine, court cost, 16 months deferred adjudication, 48 hours of community service, DWI education, victim impact panel, CAT-SNP, Smart Start Mobile for half the term, the drug offenders education course, regular UAs, and $60 to DPS.
Vince, is that your understanding of the agreement?
Yes, Your Honor. But I had emailed the ADA, and I was asking if you could probate the fine and maybe even lower the amount of probation.
When you're making a plea bargain, just make sure that you get the state's permission to come to the court and ask for any modification, because normally a plea bargain is set in concrete and is whatever you all agree to. So state, do I have the authority to modify your plea bargain, or is it a plea bargain?
Judge, we will defer to the court.
All right, and so what are you asking for, John? Go ahead.
Oh, we were asking if you could probate the fine and lower the amount of probationary time. I will make sure that the next time there's a plea that I exactly confer with them. But yeah, she's a single.
800. Go ahead.
Go ahead, Your Honor. No, she has three.
$350 is a standard fine for a reduction from DWI to obstruction of a highway in the DA's office, and it's been that way for, I don't know, 20 years. Ever since there's been an obstruction. And that's what you're paying for, basically, is a sweetheart deal, getting a deferred on an obstruction instead of a DWI conviction. Worth every penny. All right. Ms. Flores, in cause 659-538. Court accepts your plea of no contest to the offense of obstruction of a highway. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt. Place you on 16 months deferred adjudication probation. Sets an $850 fine plus court costs, 48 hours community service, DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, Smart Start Mobile Home Interlock, 4 blows a day for 8 months, which is 1/2 the term, DOEP course, regular analysis test, reimbursement of $60 to the Texas Department of Public Safety for probably a blood test. Anything further from the state or the defense on Ms. Flores?
Nothing from the state.
Okay, good luck, Ms. Flores. Thank you, Mr. Garcia.
Have a good day. Thank you, Your Honor.
We got Mr. Reynolds back yet?
Yes, Judge, I'm present.
Let's go back and see who, on Mr. Riviezo and cause 629-957, what y'all come up with?
Yes, Judge, we're on the same page. If it is okay with the state, we would like to ask the court just if y'all could consider lowering the fine a little bit. I know that that I did not discuss that with the state beforehand. My apologies.
It's already at $500. It's a DWI. You know, how much better can it be?
I don't necessarily disagree with you, Judge, but if the court can consider that his disability, we would appreciate that. Thank you.
Well, he's getting the lowest fine that basically anybody allows on a DWI, so I think he's doing good. Sorry it's that way, but it's that way. So do you want to keep the plea bargain the way it is? I'm going to deny modifying the fine amount that was agreed to in the plea bargain because it's a sweetheart deal as is.
Thank you, Judge.
So y'all want to go, everybody's happy? Mr. Riviere, any more questions or are you good?
I'm good, Your Honor. Thank you.
Best of luck to you, sir. Thank you, Mr. Reynolds. You going to proceed on your other case, Mr. Reynolds?
We're ready, Judge.
All right, this is called 664-141 to the Texas versus Orlando Laredo. And let's see what's going on with State, you got a motion on this one too, it appears.
Yes, Your Honor. The state moves to waive and abandon the 0.15 enhancement paragraph and proceed on the Class B DWI misdemeanor offense.
Objection from the defense, that will be granted. Therefore, Mr. Laredo, the charge of driving while intoxicated, first offense. How do you plead, sir?
No contest.
Is there an agreement for Mr. Laredo?
There is, Your Honor, a $650 fine, court cost 180 days probated over 15 months, 60 hours of community service, DWI education, the victim impact panel, CatSnip, and Smart Start Mobile for half the term.
And Mr. Reynolds, is that your understanding of the agreement?
That is our agreement, Judge. We're also, at the appropriate time, we'd like to ask the court to allow transfer of his probation to his home in Harris County, Judge.
To Harris County? Okay. Susan, can we transfer an obstruction probation to Harris County?
What was the time, Judge?
I'm sorry, it's a DWI, it's not obstruction. 15 months, it's over a year.
Yes, that should not be an issue.
All right, great. Can do. Let me run this by, make sure I got this straight. Mr. Laredo, in 664-141, the court accepts your plea of no contest to the offense of driving while intoxicated. First offense, I find you guilty. I said 6 months in the Bexar County Jail, probated for 15 months. That's the fine amount. Let's see, stand by. $650 plus court costs. That sound right?
Yes,
60
Your Honor.
hours service, DWI education, DWI victim impact panel, community alliance for traffic safety new intervention program, or Houston equivalent. And Smart Start Mobile Home Interlock at 4 below today for 7.5 months, which is 1/2 the probation period, and transfer to Harris County. Anything further from the state of the defense on Mr. Laredo?
No, Judge.
Good luck, Mr. Laredo. Thank you, Mr. Reynolds.
Thank you, Judge.
Yep. And we did that one. Okay, let's take a 5-minute break while I organize the next batch. Stand by.
Your Honor,
Yep, go ahead.
there is a plea paperwork for Stephen Butley that you need to sign. Please.
Okay.
Thank you.
This is for the weight, right? Yeah, until the judge actually says. Huh? What? again, let's go up. We'll see. Either way, it was in a stand, but you want to do that, you want to go to the thing?
Can everybody please mute your microphones while we're on the break, please?
Oh, they're on break.
Okay, ready to go? Pat, are you with us?
Yes, Your Honor.
All right, can you hear me?
Yes, Your Honor.
Josh, do we only have one plea with 2 cases today in the VTC, which is Ardez Molina with Don Flannery?
That's correct, sir.
Back on the record is Bear County County Court Law number 6 in the Bear County Veterans Treatment Court Plea and Probation Docket. Clause number 652749, State of Texas versus Joseph Gallardo, represented by Barry Hitchings. Mr. Hitchings, are you ready to proceed?
We're ready, Your Honor.
Thank you. Clause 614129, State of Texas versus Daniela Garcia, Jonathan Perez. Mr. Perez, are you ready to proceed?
Yes, Your Honor, we're ready.
Thank you. Clause 652891, State of Texas versus Eduardo Zuniga, represented by David Christian. Mr. Christian, are you ready to proceed?
Yes, sir.
Thank you. Clause number 629139, State of Texas versus Jasmine N. Nolly, represented by Ms. Alma Benavides. Ms. Benavides, are you ready to proceed?
Yes, Your Honor.
Thank you. And I've got 2 Bear County Veterans Treatment Court Track 1 pretrial diversion plea and probation agreements. Clause 622754 and 622755, State of Texas versus Ardez Molina, represented by Mr. Don Flannery. Mr. Flannery, are you ready to proceed?
On behalf of Don Flannery, we're ready, Your Honor.
Okay, thank you. The first document I need y'all to identify your signatures on is entitled Defendant's Consent to Plea by Video Conference. 652749, State of Texas versus Joseph Gallardo. Mr. Gallardo, is this your signature on this document, sir?
Joseph, you need, there you go.
Mr. Gallardo, can you hear me?
Just needed to unmute himself.
Yes, sir, it is.
Okay, thank you. And Mr. Hitchings, as attorney for Mr. Gallardo, is this your signature on this?
Please, Your Honor.
Thank you. And in clause 61429, Ms. Garcia, is this your signature on this document? Garcia?
Hello?
Is this your signature on this document, ma'am?
Yes, it is.
Thank you. And Mr. Perez, as attorney for Ms. Garcia, is this your signature?
Yes, Your Honor.
Thank you. 652891, State of Texas for Edward Zuniga. Mr. Zuniga, is this your signature on this document, sir?
Mr. Zuniga, turn off mute and speak up, please. I'm looking for him, Judge. Mr. Zuniga. He's been with us the whole time.
Is he still there? Eduardo Zuniga, can you hear me, sir?
Yes, I can, my brother.
Es que te miras gamba, tú misma y pues te ríes. Is he the one under Daniel? No?
Last chance, Mr. Zuniga. Mr. Zuniga.
Yeah.
All right.
He's there, Judge. I heard him. I see him too. He's on the, I heard him.
Can you hear me?
Zuniga, speak up when the judge calls you, okay?
Mr. Zuniga, can you hear me, sir? Hey, Mr. Zuniga. Houston calling. David, let's take you off the side and we'll pick up you when we finish the rest of these, okay?
Yes, sir.
All right, in clause number 629-139, State of Texas versus Jasmine N. Nolly. Ms. Nolly, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And Ms. Benavides, as attorney for Ms. Nolly, is this your signature on this document also?
Yes, Your Honor.
Thank you. Ms. Fernandez, or rather, Mr. Molina, in clause 622754 and 622755. Is this your signature on both these documents, Mr. Molina?
Yes, Your Honor.
And is this your signature as attorney taking Don's place, I guess, on both these cases?
Yes, Your Honor, and I was cooking.
Thank you. Okay, the next document I have is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions that purports to have your signature on the back. Effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Gallardo, in clause 652749, is this your signature on this document, sir?
Yes, sir, it is.
Thank you. And in clause 614-129, Ms. Garcia, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And in clause 629-139, Ms. Nolly, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And in clause 622-754 and 622-755, Mr. Molina, is this your signature on both these case documents?
Yes, Your Honor.
Thank you. By signing these documents, are each of you telling me that you've had enough time to either read these documents or have them read to you in their entirety? If you had any questions about what was on these documents, those questions were answered to your satisfaction by your attorneys, so that in signing these documents, you're telling me that you agree with and understand everything on these documents. Is that correct, Mr. Gallardo?
Yes, sir.
Mr. Gallardo, can you hear me, sir?
Yes, sir.
Is that correct?
Yes, that's correct.
Thank you. Appreciate it. Same question for Ms. Garcia. Is that correct?
Yes, sir.
Thank you. Same question for Ms. Nolly. Is that correct, ma'am?
Yes, sir.
Thank you. Same question for Mr. Molina on both cases, 622-754 and 622-755. Is that correct on both these cases, sir?
Correct, Your Honor.
Thank you. Mr. Hitchings, as attorney for Mr. Gallardo, have you had enough time to go over this case with him, and in your opinion, is he mentally competent?
I have had sufficient time, and I believe he's mentally competent, Your Honor.
Same question for attorney for Ms. Garcia, Mr. Perez.
Yes, Your Honor. I believe Ms. Garcia is.
Thank you. Same question for Ms. Benavides for Ms. Nolly.
Yes, Your Honor.
Same question for Ms. Hernandez as attorney for Mr. Molina in both cases.
Yes, Your Honor.
Thank you. And Mr. Gallardo, are you a United States citizen, sir?
Yes, sir, I am.
Thank you. Same question for Ms. Garcia.
Yes, sir.
Thank you. Same question for Ms. Nolly.
Yes.
Thank you. Same question for Mr. Molina in both cases.
Yes, Your Honor.
Thank you. Mr. Hitchings, as attorney for Mr. Gallardo, has the state fully complied with discovery for you on this case?
They have, Your Honor.
Same question for Mr. Perez, as attorney for Ms. Garcia.
Yes, Your Honor, they have.
Same question for Ms. Benavides, as attorney for Ms. Nolly.
Yes, Your Honor.
Same question for Ms. Hernandez, as attorney for Mr. Molina in both cases.
Yes, Your Honor.
Thank you. And let's see. What's going on with Mr. Gallardo? Mr. Gallardo, on clause 652-749 to the charge of theft, $100 to $750. How do you plead, sir?
No contest.
An agreement for Mr. Gallardo.
Yes, Judge. $200 fine, court cost, 6 months, Bexar County Jail, probated for 6 months, 48 hours of community service, regular UAs, ATSE, no contact with HEB store located at 6818 Zarzamora Street. And also, we ask the court TIC case number 652750. That's this case, a criminal trespass case.
Okay, defense, is that your understanding of the agreement?
It is, Your Honor.
Mr. Gallardo, on clause 652-749, the court accepts your plea of no contest to the offense of theft, $100 to $750. I find you guilty. I said 6 months in the Bexar County Jail, probated for 6 months, 48 hours community service, $200 fine plus court costs, regular urinalysis test, ATSE, anti-theft course, no contact with any HEB store in San Antonio, Bexar County, Texas during the term of your probation. taking into consideration cause 652750, which is granted, and it shall be dismissed. Anything further from the state or the defense on Mr. Gallardo?
No, Judge.
Good luck, Mr. Gallardo. Thank you, Mr. Hitchings.
Thank you.
Let's see what we're doing here. Miss Garcia, cause 614129, to the charge of criminal mischief, $750 to $2,500. How do you plead, ma'am?
No contest.
Is there an agreement for Miss Garcia?
Yes, Your Honor. $300 fine. We ask the court to probate half of this fine. Court costs 9 months, deferred adjudication, anger management course, no contact with Jesus Posada, his residence and property. Also, no contact with 1810 East Sonterra Boulevard. Also, Judge, part of the agreement is to pay restitution, if any, to Jesus Posada. The amount is to be determined.
Okay, State, I don't think I got this case on your plea bargain list. Yes, I did. Don't pay the ransom. I escaped. I found it. Okay, and defense, is that your understanding of the agreement? And again, I'm sorry.
Yes, Your Honor, that's our understanding of the agreement, that 150 of the $300 fine will be probated, Judge. She's a student, she just finished school, and I don't believe that any restitution will be necessary, Your Honor. I know the state's got to make their announcement, but I don't think there is any.
Okay, that'd be a good thing. Okay, Ms. Garcia and cause 614129, the court accepts your plea of no contest to the offense of criminal mischief, $750 to $2,500. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt, place you on 9 months deferred adjudication probation. That sets a $300 fine, probating $150 of that, plus court costs. No community service on this one, is that correct?
Anger management, Judge.
All right, APSE, anger management course. No contact with Jesus Parada, his residence or property. No contact with 1810 East Sonterra Boulevard, Texas 78259. And pay restitution, if any, to Jesus Posada. Anything further from the state or the defense on Ms. Garcia?
No, Your Honor.
Nothing further.
Good luck, Ms. Garcia. Thank you, Mr. Perez.
Yes, sir.
And let's see what we're doing on Miss Nolly here. Okay, Ms. Nolly, and cause 629139 to the charge of failure to stop and give information. How do you plead, ma'am?
No contest.
Is there an agreement from Ms. Nolly?
Yes, Your Honor.
Your Honor, a $0 fine, court cost, 1 day Bear County Jail, credit for time served, time and money to run concurrent. And if it pleases the court, we ask that this judgment be satisfied. And the state will also be taking into consideration cause number 648836.
Okay, for some reason, this didn't make it on my cheat sheet either. So let me go over this one more time. It's going to be 1 day in the Bear County Jail. What fine is there going to be?
A $0 fine, Your Honor.
$0 fine plus court cost. And credit for time served, time and money to run concurrent, JSAT taking into consideration cost 6488. And what is the numbers?
36, Your Honor.
648836. And what kind of case is that?
That is a reckless driving case, Your Honor.
Oh my. Okay.
This deal was brokered in another court. The defendant pled to another charge.
Okay. Ms. Benavides, is that your understanding of the plea bargain?
It is, Your Honor.
Okay, make sure I get this right. Ms. Nolly, in cause 629139, the court accepts your plea of no contest to the offense of failure to stop and give information. I find you guilty. I says 1 day in the Bear County Jail, $0 fine plus court costs. Credit for time served, time and money to run concurrent, take into consideration cost 648836, which is granted and it shall be dismissed, judgment satisfied. Anything further from the state of the defense on Ms. Nolly?
No, Your Honor.
Good luck, Ms. Nolly. Thank you, Ms. Benavides.
Thank you. I can exit, correct?
Yes, ma'am, you can. You know, you have, oh, you're good, ma'am. Thanks for your help. Okay, we now have 2 Bear County Veterans Treatment Court, track 1 pretrial diversion plea and probation agreement. State of Texas versus Audaz Molina, cause 622754 and 622755. In cause 622754 to the charge of unlawfully carrying a handgun. How do you plead, Mr. Molina?
Guilty.
Court accepts your plea of guilty. Hold it in abeyance. Places you on 1 year. Bear County Veterans Treatment Court, track 1, pretrial diversion probation, setting a $1,000 all-inclusive veteran treatment court fee, 48 hours of community service, probating all that based on your military service. Let's see what else y'all agreed to on this. DWI intervention, back panel, smart start mobile, home interlock at 4 blows a day for 1/2 the time, which is 6 months. Firearm safety course. What kind of gun is it? I know it's a handgun. What make is it?
It's a Ruger 9mm.
All right. Mr. Hernandez, would you, in the lieu of destroying this weapon, would you and Mr. Flannery accept it as additional attorney's fees if Mr. Molina agrees?
Yes, Your Honor.
Is it okay with you, Mr. Molina?
Yes, Your Honor.
Thank you. Okay, state's motion to destroy and/or forfeit weapons, respectfully deny weapon awarded to defense counsel with additional attorney's fees not to be returned to the defendant, his family, or his friends. Successful completion of the Veterans Treatment Court issue judge's bond. Defendant to be supervised by VTC staff and CSCD. At this time, Mr. Molina, I'm looking at a contract which is entitled Track 1 Pretrial Intervention, and I'll just go over this once for both cases. There's a similar contract in the other case, 622755. Said contract setting out all the terms and prerequisites of your successful completion of the Veterans Treatment Court. In fact, Mr. Molina, is this your signature on this document in both cause 622754 and 622755?
Yes, Your Honor.
And let me get there. Mr. Hernandez, would you identify Mr. Flannery as the primary attorney on this case, signature on this document in both cases?
Yes, Your Honor.
And Assistant Criminal District Attorney Guillermo Flores, is this your scratchy little signature I'm seeing here with a big G?
Yes, Judge.
That's what I thought. And that would be on both cases, right, Guillermo?
Yes.
Okay. I think we're good on that one. Josh, what did I forget on this one?
Got it, sir. Mr. Molina, Mr. Morrow will be calling you right after this, once you log off, and give you instructions for what's to come next with your orientation, okay?
Thank you.
Okay, let's finish up. Mr. Molina, class 622755 to the charge of driving while intoxicated, second offense. How do you plead, sir?
Guilty, Your Honor.
Court accepts your plea of guilty, holds it in abeyance, places you on 1 year, Bear County Veterans Treatment Court, track 1, pretrial diversion probation, assessing a $1,000 all-inclusive Veterans Treatment Court fee, 48 hours of community service, probating all that based on your military service. DWI intervention program, DWI victim impact panel, Smart Start mobile, home interlock at 4 blows a day for 1/2 the term or 6 months. Firearm safety course, state's motion to destroy or forfeit the weapon is respectfully denied. Weapon awarded to defense counsel. Additional attorney's fees not to be returned to the defendant, his family, or his friends. Successful completion of the VTC. Issue judge's bond. Defendant to be supervised by CSCD and VTC staff. And we just went over this contract on the last case. They're both identical. Do you have any questions on what we're doing, Mr. Molina?
No, Your Honor.
What'd you do in the military, sir?
I was a 19 kilo M1 tanker back during Desert Storm. I thankfully wasn't deployed, but that was during that period.
Okay, well, thanks for your service, sir.
Yes, Your Honor.
Anything further from the state of the defense on Mr. Molina?
No, Your Honor.
All right, thank you, Mr. Hernandez. Thank you, state, and good luck, Mr. Molina, and Mr. Moore will be contacting you to reel you in, okay?
Thank you, Your Honor.
We're good on that one. What else we got today? MTRs. And Mr. Christian, did you ever get Mr. Zuniga's combo situation fixed?
Judge, I communicated him via text, and he says he can hear us, but obviously we can't hear him. I still see him on your screen. Mr. Zuniga, can you hear us?
Yes, sir.
Say it one more time, because you're kind of cutting in and out. Stay still and just answer. Can you hear us?
Yes, sir. Still can hear you.
Let's try it. All right, Mr. Zuniga, this is called 652891, State of Texas versus Eduardo Zuniga. The first document I need both you and Mr. Christian to identify your signatures on is entitled Defendant's Consent to Plea by Video Conference. Mr. Zuniga, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. Ms. Christian, as attorney for Mr. Zuniga, is this your signature on this document?
It is, Judge.
Thank you. And state, looks like you got motions on this one too.
Yes, Judge. The state moves to amend the information to include an obstruction count and proceed on the obstruction count, Judge. Also, the state moves to waive count number 1, which is the DWI.
Mr. Zuniga didn't make it to my cheat sheet from the DAs. All right. So this started out life as a what? DWI first offense?
Yes, Your Honor. He should be on the sheet above Miss Nolly.
I don't have Miss Nolly's sheet either for some reason. This is one of those that got lost in the shuffle between last week and this week. Not your fault. All right, we'll just do it. Stand by. State's motion to amend the information, adding paragraph 2 alleging obstruction of a highway. No objection from the defense is granted. State then waiving paragraph 1 and proceeding on paragraph 2, obstruction of a highway. No objection from the defense is granted. To the charge of obstruction of a highway, Mr. Zuniga, how do you plead, sir?
Well, guilty.
All right, thank you. And is there an agreement from Mr. Zuniga? I apologize, let's go through it again.
Yes, Judge. $650 fine. Court costs, 16 months deferred adjudication, DWI education, VIP live, CAT-SNP, Smart Start mobile device for half the term, 48 hours of community service, regular UAs, and pay restitution to DPS in the amount of $60 for the lab.
And Mr. Christian, is that your understanding of the agreement?
Yes, sir.
Okay, Mr. Zuniga, in cause 652891, the court accepts your plea of guilty to the offense of obstruction of a highway. Although I have enough evidence to find you guilty, I'm going to withhold the finding of guilt. Place you on 16 months, deferred adjudication probation, assessing a $650 fine plus court cost 48 hours community service, DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drugs, Smart Start Mobile at 4 blows a day for 8 months, which is 1/2 the term, regular analysis tests, reimbursement to the Texas Department of Public Safety for lab fees in the amount of $60. Anything further from the State of the Defense on Mr. Zuniga?
Yes,
No, Your
sir.
Honor.
From the defense, Judge, okay, here's the situation briefly. You ordered this gentleman to have mobile Smart Start a long time ago. The order was sent to pretrial services. Pat Benavides has resent it to them. The place that he has the ignition interlock will not remove it. They are not acknowledging the order to remove. I can't figure out why. So I need you to get like real mad at them and tell them they have to remove it, because he's had interlock and the device the entire time since you ordered the removal of it. I don't know what the problem is. Pretrial's not been responsive to me.
What is the name of the company that he's got this ignition interlock device from?
Mr. Zuniga, can you hear the judge? What's the name of the company?
Dragger.
Jaeger, Jagger?
Draggey.
Draeger, gotcha.
Bigger.
David, do this, get a copy of the contract or whatever and send it to me by hook or by crook. Have you already made a pass at him, Dave?
Yes, I have, Judge. They're just saying that they don't recognize the order that has your, it's from you. So I will, I'll swing by and get with y'all and work on it.
Give me a copy of the contract and a phone number and maybe a point of contact, and I'll make the call. It's not a problem.
Thank you, sir.
All right. Good luck, Mr. Zuniga. Thank you, Ms. Christian.
Thank you.
Okie dokie. And Dave, well, we got you. You ready to go forward on this floor?
Yes, sir, I am.
Okay. Cause number 633-156, State of Texas versus Caroline Flores. This is a second amended motion to revoke community supervision. Ms. Flores and Mr. Christian, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have your signatures on it. In fact, Ms. Flores, is this your signature on this document, ma'am?
Yes, sir, it is.
Thank you. And Mr. Christian, as attorney for Ms. Flores, is this your signature on this document?
It is, Your Honor.
Thank you. The next document I'm looking at, Ms. Flores, is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Ms. Flores?
It is, Your Honor.
Thank you. And Mr. Christian, as attorney for Ms. Flores, is this also your signature on this document?
It is, Judge.
This is a second amended motion to revoke community supervision. My understanding is this is going to be an uncontested motion to revoke community supervision. Is that correct, Mr. Christian?
That's correct. It'll be a plea of true with an explanation, Judge.
Okay, Ms. Flores, on the second amended motion to revoke community supervision and cause 633-156, how do you plead, ma'am?
I plead true with explanation.
Fair enough. Ms. Gross, I remind you, you're still under oath. Would you please advise the court and the parties of the status of Ms. Flores' probation, please?
Yes, Your Honor. Ms. Flores was doing well with her reporting up until we last saw her on May 21st of 2021. So she's missed the last 2 months of reporting. She's paid $1,544, has a balance of $60 towards her fees, and she is current at this time. She's completed all 60 hours of her community service. She's also successfully completed DWI education, victim impact panel, a stress class, and the CATSNP programs. She has been on the Scram device and has had some issues with that. She has failed to submit to drug testing on 2 occasions. She's had 4 negative drug tests. She's had 6 positive drug tests, which include 3 for alcohol, 2 for methamphetamines, and 1 for amphetamines. Her criminal history includes obstruction of a highway, assault, bodily injury, and a harassment of a public servant, which remains in night mag status at this time. Her officer is recommending that she go to SATF, followed by aftercare. This is her third MTR, or I'm sorry, third violation report and her second MTR.
Mr. Christian, what are you requesting?
Judge, let me just help on a couple things, and I'll give you my request. The pending cases that were discussed, I believe they were taken in consideration as a result of this plea. I just confirmed that. So I don't want you to think there's anything else pending. It was some stuff that went down that night that was taken in consideration, Judge. Judge, the explanation on the missing the condition number 5, she reported in May. She says she did not hear anything in June or July, and finally got notice of a July, that in July, late July, that she had a new probation officer. So that's going to be her explanation for that. The condition number 2, the methamphetamine and amphetamine, Judge, she's going to plead, she has pled true to it. She's going to tell you that it's Adderall. Is her response to that. She does not have a prescription for Adderall. She received that from a friend. She is a student. She also works, and she used Adderall without a script. As far as the alcohol, Judge, I've had some heart-to-hearts with her. She is adamant that she has not used alcohol. I took her in the woodshed and really told her it's not going to hurt you if you just say it, but she will not admit to alcohol. And so she's willing to tell you that too, Your Honor. My request is this. My request is that this young lady has been diagnosed with depression, with anxiety, with PTSD. She saw a psychiatrist as recently as May who prescribed her 2 medications. She has a very involved family that want her to get some help. If the wait time for MyOff was 1 day, then I would say send her to MyOff. If the wait time was for any type of inpatient was 1 day, I would say please, please, please send her to inpatient. But right now the wait time is just so significant, Judge. I think my request will be to continue her, but to give her intensive outpatient with the Center for Healthcare Services to address the mental health issues that this young lady has, to continue her on Mobile Smart Start, to continue her on the random UAs and frequent UAs is my request. In lieu of that, Judge, I would ask that you reform the underlying judgment to a 90-day sentence if you don't want to continue her. Right now, Judge, I just SATF and MyOff, the wait is just too long. This family can get her their own inpatient. They can help her a lot faster. And so I have the dad here with me. He's on the same page. Ms. Flores is on the same page. So that's my request. Continue with intensive outpatient, Center for Healthcare Services. Let's address the mental health issue. If not, reform the judgment to 90 days or less, and then we'll get her out and get her into some kind of private treatment, Your Honor.
Susan, what was the original fine on this case, if you know?
$500, Judge.
Susan, will Adderall test positive for methamphetamine?
No. And she's already stated that it was Adderall that did not belong to her. She used somebody else's prescription.
Yeah, but it won't test positive for methamphetamine is my question, I guess. Regardless.
That's correct. That's correct. She had 1 positive for the Adderall, which is amphetamines, and then she had 2 positives for methamphetamines.
Okay, and then as far as getting a lady into either SATF or MyOff, what is the wait circumstance as of today?
As we discussed earlier, Judge, it's going to take probably a couple of months after medical clearance, and some people are taking upwards of 3 months to get medically cleared.
Okay, and Mr. Christian, I'm still confused on this reporting thing. They say that she stopped reporting back, what, at June or May is the last time they saw her or had any contact with her? Does that sound right, Susan?
Yes, sir. I'm sorry, go
Yeah.
ahead, Susan. Yes.
Yeah, the last time we saw her was May 21st, and she is correct. She did have an officer change, but we also emailed and texted her appointments for her to attend via Zoom due to the COVID situation, and she failed to show up for those appointments, Judge.
You have an answer for that?
Can I, if I may, Judge?
With your attorney's permission, absolutely.
Yes, Ms. Flores, please go ahead.
Hi, Judge. So I will be honest, as far as email communication, I was in contact with my probation officers. I did have a issue connecting with from April to May with my new probation officer. So it was Grace, I believe is Martina. I can't remember her last name, but my initial probation officer I had lost communication with, so I had to call into the probation office and locate my new probation officer. And so that's when I was told that month of May that I had a new one. I met with her via Zoom and we talked about scheduling something for next month, but I never heard back. And usually the way the court system works is that it would send me a text and tell me, hey, you have a upcoming Zoom meeting with your probation officer, you know, and then I would confirm via email. I did not have any email communication. I save all of my email communications from Bexar County because I receive the workforce ones as well. The latest one that I have is, I believe it was July 31st. I can't confirm because, you know, I can't check my email, but I do have the latest confirmation with the previous second probation officer that said I was able to get a new one and that I would be meeting with my new one this following time. So then I was able to confirm, you know, the time in August. So as far as reporting, you know, I do have my phone. I usually am very proactive with that. So, you know, I will stand by that. I did not, I wasn't, you know, avoiding reporting. I didn't have a set time or date confirmed with me, and usually I'm pretty good about following up with those. So if it was via Zoom, I just wasn't aware.
And Judge, I've reviewed the case and it looks like that appointment for June was given to her verbally in May, and then a Zoom link was emailed to her at a later date.
Okay, state recommendation.
Your Honor, the state agrees with probation status recommendation.
Okay, Ms. Christian, I think you've already answered this question, but for purposes of the record, we would all be happy if she would go to SATF, and I agree with you wholeheartedly that it's unreasonable for the time frame that we're now dealing with before she can ever walk in the door of the rehab facility. She'll probably be 2 months in jail before the rehab facility. So my offer is either A, if she wants to volunteer for SATF, I'll do whatever I can to keep her in jail minimally before she gets there, but you know as well as I do, I have no real control over that. And 2, if she doesn't want to do that, I'm going to sentence her to, instead of the year that she could get, I'm going to give her 180 days in jail. So her options are either volunteer for SATF or go to jail for 180 days, which is, you know, I don't know what the sheriff's quotient is these days, 2 for 1, 3 for 1. I have no idea what they're doing. She has 17 days credit by my records.
Judge, thank you for the option. I'd just like to point out that I believe the underlying on this one, because Susan and I talked, the underlying happens to be 6 months for some reason. I think it's because it was already adjudicated. It was 180 over 2 years.
Susan, I don't know. Obviously, I don't have access to that record. Does she have a 6-month underlying? I mean, that my punishment still fits within that parameter.
I know. But now's the part where I asked you to go less in the.
It's very unusual for me not to have a maximum underlying sentence on a case, though. That would be unusual.
Yes, Judge, it was 6 months, probated for 2 years.
Okay.
That's correct, Your Honor.
Do you want to go in a breakout room and chat with her about the possibility of SATF, or do you already know what y'all want to do, Mr. Christian?
Sir, I'd like to talk. Go ahead, Ms. Flores. You want
If
to
I
talk?
may speak directly with you, Judge, I want to say I am all for your recommendations as far as treatment, sir. I have spoken with my family, and since being diagnosed since this accident, once again I stand by that this experience has completely changed my life, sir. And as far as the underlying issues, I stand by not drinking. I have changed my life. And my family and I agree that I do need help, but for my mental health, and I just don't feel like SATF is going to 100% address that. So I will meet with Susan in the breakout room, but I agree with me and my family agree that I need other treatment. So,
So let me interrupt and say, Judge, I'll go in the breakout room with her. And so I guess, can you give a third option, MyOff, SATIF, or 6 months?
That's correct. Either my or SATF's okay with me, whichever one she can get into. I don't know.
All right, I'll talk to her and get right back to you.
All right.
And David, just keep in mind those timelines that we discussed. It's going to apply for either one because she's got to go through medical.
Yes, ma'am. We're going to talk about that. Thank you.
All right.
I'll put her in and I'm doing that right now. Let me get her in there. Let me find her. There she is. I think I put you all in for.
And Alma, are you ready to go forward on Mr. Buckley's cases?
Yes, Your Honor, we're ready.
See what we're dealing with here.
Ms. Flores, there should be a button for you to hit to go into a breakout room. It should say join. Somewhere, okay. Go in there with Mr. Christian.
Okay, I'm kind of confused. We've got an MTR in cause number 645288 on Mr. Buckley, and then there's also plea documents on 663897, correct?
That's correct, Judge.
All right, so let's do the MTR first and see where that goes, and then that may or may not affect actual plea situation. This is cause 645288, State of Texas versus Steve Buckley. Mr. Buckley and Mr. Buckley is represented by Ms. Alma Benavides, and I neglected to say this earlier. Representing the state are two criminal assistant district attorneys, Guillermo Flores and Megan Galloway. Representing the Bexar County CSCD Probation Department is Ms. Susan Gross, who our mind is still under oath. Mr. Buckley, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have your signature on it. Is this your signature, sir? And your microphone's turned off, sir. You need to turn your mic on. Thank you.
Yes, Your Honor.
Thank you. And Ms. Benavides, as attorney for Mr. Buckley, is this your signature on this document?
Yes, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal. Is this your signature on this document, Mr. Buckley?
Your Honor, it is.
Thank you. And Ms. Benavides, as attorney for Mr. Buckley, is this also your signature on this document?
It is, Your Honor.
Thank you. This is a motion to enter adjudication of guilt and revoke community supervision. My understanding is this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that accurate, Ms. Benavides?
Yes, it is, Your Honor.
Mr. Buckley, in cause 645288 on the motion to enter adjudication of guilt and revoke community supervision. How do you plead, sir?
I plead true, Your Honor.
Thank you. And Ms. Gross, would you please advise the court and the parties of the status of Mr. Buckley's probation?
Yes, Your Honor. Mr. Buckley has performed very poorly on probation in that we have not seen him since March 15th of 2021, which is the day that he went through orientation and signed his conditions. He has paid $150 towards his fees, has a balance of $557, and is delinquent $532. He's not completed any of his community service hours. He's never had a drug test because we've never seen him. And this is his first violation report, first motion to revoke. He has been arrested and charged with a new criminal trespass since being placed on probation. And his criminal history includes the following arrests. He has been arrested for possession of marijuana 0 to 2 ounces, resisting arrest, search, transportation, theft of service 20 to 500, criminal trespassing, private property, possession of a controlled substance penalty group 1, 1 gram to 4 gram, which remains in night mag status. This probation case, and then he has a new criminal trespass pending. This is his first violation report, first MTR, and the officer is recommending revocation, and his original fine is $200.
Is indecent exposure a class B, I'm guessing? Does that current sound right?
Judge, it is a class B, yes.
It's class B, is that correct? Everybody agree?
Yes, Judge.
All
Yes,
right.
Judge.
Ms. Benavides, what is your request, please?
Your Honor, we're asking the court to revoke and reform. Mr. Buckley has 126 actual days in jail credit on this indecent exposure. So we're asking for the court to revoke and reform into JSAT.
And state recommendation, please.
Yes, Judge. State recommends that the court enters an adjudication of guilt, revoke probation, and we agree with the JSAT.
Mr. Buckley, in cause 645-288, court accepts your plea of true to all conditions on the motion to revoke probation with an explanation. I grant the state's motion to enter adjudication of guilt and revoke community supervision. I find you guilty of the offense of indecent exposure. I sentence you to 180 days in the Bexar County Jail. It says a $2,000 fine plus court costs, credit for time served, time and money to run concurrent. Obviously, you're going to get credit for this 126 days. And state, do I have your permission to take into consideration clause 633156 on this MTR and 645-288?
Well, Judge, with Ms. Benavides's permission, the state has a recommendation in that case, given the specific facts. Judge, I can explain that to the court right now, or I can wait until the defendant takes a plea. We're basically just, the state wants a no contact order, but if the defendant remains in jail, then
Okay. Let me make sure I understand. So you don't want a TIC, this criminal trespass case, you want to go ahead and process the plea. So when he gets out of jail, he'll be on probation on the plea on criminal trespass. Is that correct?
Yes, Judge.
Man, Ms. Benavides, they're getting tough on you here.
Your Honor, that is our agreement, and that was what we had talked about. That's what I talked about with the state and with my client, and my client was in agreement to apply for probation on this case, and the state was in agreement to offer him probation.
I'm gonna let the sheriff figure out all this day stuff, but it sounds to me like he's got a JSAT probably. Let's talk about clause 633156. Oh, wrong one. Let's try again. Bingo. Let's talk about clause 663897. Mr. Buckley, I'm looking at a document entitled Defendant's Consent to Plea by Video Conference that purports to have your signature on it. Is this your signature, sir?
Your Honor, again, it is.
Thank you. And Ms. Benavides, as attorney for Mr. Buckley, is this your signature on this document?
Yes, Your Honor.
Thank you. Mr. Buckley, the next document I'm looking at is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions that purports to have your signature on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, sir, is this your signature on this document also?
Your Honor, it is.
Thank you. By signing this document, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney, Ms. Benavides, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, sir?
Your Honor, my competency is accurate. Yes, sir.
Thank you. Ms. Benavides, as attorney for Mr. Buckley, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
Yes, Your Honor.
Mr. Buckley, are you a United States citizen, sir?
I am, Your Honor.
Ms. Benavides, has the state fully complied with discovery for you on this case?
Yes, they have.
Mr. Buckley, in cause 663897 to the charge of criminal trespass, how do you plead, sir?
No contest, Your Honor.
And state, is there an agreement for Mr. Buckley, please?
Yes, Judge. There's a fully prorated $150 fine, court costs, 1 year Bexar County Jail, prorated for 6 months, regular UAs, and no contact with Linda Estrada and her residence and property. And also, Judge, we ask for a no contact with 1315 Rio Linda, San Antonio, Texas, 78245.
Let me see if you're on my sheet. Nope. Okay, I apologize. Let me make sure I get this correct. No contact with Linda Estrada. Does that sound right?
Yes,
Or her residence and property.
Yes.
And then there's an address 1315, and I think you said Rio, R-I-O. Is that correct?
yes.
Judge.
And then the next word after Rio is what?
Linda,
Rio Linda. Okay.
Right.
San Antonio, Texas, I'm assuming.
yes,
And okay, and we're providing all of the fine, correct?
Correct.
It's is this a class A offense?
Yes, Your Honor.
The habitation, is that what we're doing?
yes.
So make sure I get this right. Mr. Buckley, in cause 663-897, the court accepts your plea of no contest. I find you guilty. I assess 1 year in the Bexar County Jail, probated for 6 months, $150 fine, probating all of that plus court costs. Regular urinalysis test, no contact with Linda Estrada and or her property or residence, and no contact with 1315 Rio Linda, San Antonio, Texas. Does that sound right, defense?
Yes, Your Honor, that's correct.
State, does that sound right?
Yes, Your Honor.
That's the plan. Good luck, Mr. Buckley.
Thank you, Your Honor.
That's all I got.
Judge, just to follow up, we're still staying revoked on the probation case, but granting on the new one, correct?
Correct.
Thank you.
Thank you, Judge. May I be excused?
Yes, ma'am. Thanks for all your help.
Thank
you. Okay, we did those two. And we did that one. Mr. Christian is still with us?
They're in a breakout room, Your Honor.
Oh, that's right. I've got Quattro Neville's left. What else do I have left?
The Spanish speakers and Quattro Neville's.
All right, did we get all the Spanish speaker technology working?
We hope so, Your Honor. We're hoping that it works.
Let's find out. We got Mr. Papidis with us today?
Yes, he's here.
Present, Your Honor.
Let's do cause 3. This is all Spanish, and I haven't turned on my Spanish interpretation deal yet. Let's see. Okay. It's cause 332903, State of Texas versus Alan Beltran Velez, represented by Mr. Alfonso Bafidis. This is a motion to revoke community supervision. Mr. Beltran Velez, I'm looking at a document titled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both your signature and your attorney's signature on it. Mr. Beltran Velez, is this your signature on this document, sir?
He's muted. There you go.
Yeah, I'm trying to get into, and there you go. There you go. See.
All right, thank you. And Mr. Bafidis, as attorney for Mr. Beltran Velez, is this your signature on this document?
It is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Mr. Beltran Velez?
Así es.
And thank you. And Mr. Bafidis, as attorney for Mr. Beltran Velez, is this also your signature on this document?
It is, Your Honor.
My understanding is that this is going to be an uncontested motion to revoke community supervision. Is that accurate, Mr. Bafidis?
Can you repeat that again, Your Honor?
This is going to be uncontested, meaning you're not requesting a contested hearing on this motion.
No, Your Honor.
Okay. Mr. Beltran Velez and cause, I can't read it. Let's go over here. (332-903). On the motion to revoke community supervision, how do you plead, sir?
Culpable.
It's either normally true with an explanation or not true with an explanation.
Your Honor.
Perdón.
Mr. Bafidis, would you like to chat with your client?
Yes, Your Honor.
I
Okay.
I don't think they need to go to a breakout room. They just need, Mr. Beltran Velez needs to understand what's going on with this case and what the plea situation.
Alan, vas a decir que es es cierto a todas las condiciones, ¿ok?
Ok. Ok.
So once again, on this case, what on 332-903 on the motion to revoke community supervision, how did Mr. Beltran Velez plead?
Es cierto.
Thank you. Ms. Gross, who our mind is still under oath, would you please advise the court and the parties of the status of Mr. Beltran Velez's probation?
Yes, Your Honor. Mr. Velez has performed very poorly on probation in that he only reported twice. And we last saw him in the Bexar County Jail on December 10th. I apologize, December 21st of 2010. He's paid $199 towards his fees. He has a balance of $1,204. He has not completed any of his 48 hours community service. He did have one negative drug test. And we have no proof of enrollment or completion in DWI education, victim impact panel, ignition interlock, obtaining an alcohol evaluation, or starting anti-abuse. This case did expire August 22nd of 2012. This is his first violation report, first motion to revoke, and his officer is recommending revocation.
And what was the original fine amount on Mr. Velez's obstruction case?
Judge, he has no fine and he has one prior arrest for theft.
Okay. And Mr. Bafidis, what is your request, sir?
Honor, I had sent I sent the DA, Mr. Flores, a letter showing that my client had been incarcerated for 4 days in Crystal City. For there was a warrant for his arrest. It was from August 12th through the 16th. So I was requesting that the court consider a judgment satisfied based on those 4 days of arrest. You know, he was unable to work for 2 weeks. He's a driver who he's an independent contractor, delivers services for hospitals and major corporations like Home Depot, UPS, and Amazon. As a result of that arrest, he was unable to work for 2 weeks. His employer found out about it, and they asked that we address all this. This is why I asked for that motion to set bond. He didn't have that bond, if you recall. And once you set the amount, his employer finally let him start working again. He started working on Monday. This is an old case, 2010 case. Since 2010, he hasn't had a single violation of the law, not even a speeding ticket. And Mr. Flores can, if he ran his background, he can attest to that. He's the breadwinner of his house, so that loss of income definitely had a huge impact on his household. He left Bexar County to go to Louisiana for purposes of work. They offered him a job over there. He left. It's not a good excuse. He knows that it was a dumb decision, but at the time, for him it was easier to leave and not report. I guess that's it was his decision. He didn't think it would come back and haunt him 10 years from then. And he was pulled over for a broken taillight, and that's when they found out that he had that arrest warrant for his probation violation. I think those are all the facts of the case, Your Honor. If it's not possible to get us judgment satisfied, then I would also ask for the court to consider a judgment unsatisfied if possible. And that's all I have for the court.
Thank you. State recommendation.
Revocation, Judge.
Mr. Beltran Velez, in cause 332903, the court accepts your plea of true. On the motion to revoke community supervision, I grant the state's motion to revoke your community supervision. I sentence you to 6 months in the Bexar County Jail. Assess a $0 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. on Monday, September 6, 2021 to start your sentence. Anything further from the state of the defense on Mr. Beltran Velez?
No, Judge.
Good luck, Mr. Beltran Velez. Thank you, Mr. Rafidas.
Thank you, Judge.
Mr. McCrum, are you ready on Mr. Jorge Flores de Lea?
Yes, sir, Your Honor.
Let's try. Thank you for being patient. I know it's been an all-day deal. This is cause 644808. State of Texas versus Jorge Flores de Lea. This is a motion to enter adjudication of guilt and revoke community supervision. And representing the state, Assistant Criminal District Attorney Guillermo Flores and Megan Galloway. Representing the Bexar County CSCD is Ms. Susan Gross, who I will remind is still under oath. Mr. Flores de Lea, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have your signature on it. Is this your signature on this document, sir?
No escucho el intérprete.
Interpreter, would you go ahead and try and communicate with them and see if we're still having a communications lag?
No escucho el intérprete.
He's saying he doesn't hear the interpreter.
Pat, over to you.
Bueno, señor Flores, hay 3 puntas, necesita, por favor, apuntar esto, cambiarlo, por favor, a español.
Okay.
Para que puedes oír el intérprete.
Ya.
Ok, trátala, por favor.
Pat, is there a way to fix the communication between the interpreter and the defendant?
He has to, Your Honor, there's something on his phone he has to change.
Did he do it?
I don't know. Señor Flores, ¿podías hacerlo?
Sí, ya lo hice.
¿Puedes oírla? El intérprete.
Aún no.
¿Lo cambiaste a español?
Sí, lo cambié a español, pero no escucho a nadie más, nomás el juez.
Ms. Valle, can you hear him at all? Hear him?
Mr. McCrum, I don't know how to fix it.
I don't either, Judge.
I guess we just need to reset.
I
Miss,
mean,
hold on. Ms. Valle, can you hear him?
Okay. Ya lo puse en español.
Okay,
But he cannot hear Miss Valle, apparently.
that's what he's saying. ¿Todavía no puedes?
Ahora sí.
Sí, yes. Ahora he can. He now.
He can hear Miss Valle?
Yes.
Miss Valle, would you go ahead and confirm with the Flores that y'all can communicate?
She's trying to get him to put up his hand so that it shows that he hears her.
Yeah.
Señor Flores, ¿puedes oír el intérprete?
No.
No.
I guess just have to reset it again, Judge.
Okay.
How did y'all fix it earlier, Pat? Did you do something?
I didn't do anything. I told him to press the
We
stamp.
went into a breakout room and it was working in the breakout room.
Yeah, it was working in the breakout room.
Well, can you send Miss Valle and Mr. Flores to a breakout room and see if that fixes it?
I can, Your Honor, but you've got other people waiting, so I didn't know whether you want to try for them and what do you want to do? I'll send him to a breakout room right now, see if that helps, just real quick. Okay, Mr.
Of course.
Sick.
Of course.
And let me see, Mr. McCrum, where you
Two,
are.
right?
Hold on. I gotta find you in where there you go. Let me see.
Would it help, Pat, if perhaps the defendant signed out and signed back in and that might do something, or do you know?
It might. I'm gonna send him to the breakout room real quick right now and see if they can send it.
All right, we're not going to spend a lot of time. If you can fix it, that's great. And if you can't, we'll just reset.
Okay, let them go
Judge,
right now.
On Joanne De Hoyos' client, can we test if he can hear the interpreter?
Is Mr. Castaneda Bravo?
Mr. Castaneda,
Yeah,
can you
let's
hear
see
the
if it's the
interpreter?
issue. It may just be, hold on, I'm going to go in right now. Hold on.
Oh, and the interpreter is in the breakout room. Never mind.
Yeah.
I think Mr. Christian broke it. That's what I'm going to tell everybody.
Would it break all the rules to put you and the court reporter judge in the breakout room also? I don't think anybody would care.
Whatever works. But then the other parties, will the state be able to hear? Will Ms. Gross be able to hear at that time? I mean, everybody's got to be able to hear.
You know what? Let me retract. I don't know what I'm talking about.
Your Honor, he is going to sign in and sign out. It wasn't working there.
All right.
So we're going to get them back into the main room.
But while we're waiting for that, can Ms. Valle try talking to Henry Castaneda to see if his audio works?
¿Puede oír el intérprete?
No lo escucho.
He can't either.
Oh, no. Okay.
He can't do it. Okay. Señor Castañeda, busque 3 puntos. Prima eso. Y
Sí.
cambia a español.
Ok, ya lo cambié.
¿Puedes oírla?
Sí, te escucho, te escucho.
¿Puedes oír el intérprete?
No, no,
Okay.
no lo escucho.
Okay. Trata ahora. ¿Puedes oírla?
No, no lo escucho.
Hey, go ahead. Okay, as of right now, he still cannot hear the interpreter. Does that sound right, Ms. Valle?
Neither can Mr. Castañeda either. Okay.
Flores Elia logged off and back in. Maybe we can ask him if he can try again.
Okay. Señor Flores. Señor Flores, ¿puedes
Sí.
oír el intérprete?
No.
Ask him to put it, make sure and put it on Spanish, Pat.
Por favor, prima los tres puntas y cambia a español.
Es que lo pongo en español y automáticamente después se vuelve a poner en audio original.
Oh, what he is saying, did you hear him, was that he hits the Spanish button and then automatically it will switch back to the original language. So it sounds like it has to do with his phone. He can't hear.
I can hear you, but I cannot hear Pat. Her audio.
Yes, yeah. Her audio is very, very faint. It fades in and out, but she can hear you.
Okay, let me do that then. Let me mute. There you go. Try that now. Can y'all hear now?
I can hear you, Pat.
Okay. The person, yeah, not the Spanish. Not the Spanish.
Does Mr. Flores understand he has to
Yeah.
hit the little button that says English or something on it so that he can communicate?
Señor, yeah, hold on, Judge. Señor Flores, trata otra vez a primer los tres puntos y poner español. Yo cambié algo en el computador. Trata ahorita.
Ya.
¿Ok? Ahora.
No.
No.
Nadie, no escucha a nadie.
No. He doesn't talk. He cannot hear anybody.
Okay, either Scott, y'all we'll just cut you loose and reset for another day, which I apologize it's that way, but it's that way, or you can hang around and we can, maybe Pat can sign out everything and sign back in and start over. I don't know if that makes a difference on these systems or not.
I don't know, but obviously we have not ever had this problem before. So I don't know whether it's just messed up or what, because we have never had this problem. Never.
But it's with more than one though, right, Pat? It's two
Yes,
of them.
it's more with the, it's not just this one, it's
That's
also
correct,
with Mr.
Mr. McCrum.
Castañeda. And I'm sure, I don't know whether Daniel as well.
No. Check.
I don't know what else.
Scott, we're gonna do this again tomorrow afternoon, actually tomorrow morning at 10 and tomorrow afternoon at 2. Do you want to try and pick into one of those?
Yes, sir, for sure.
Whatever's better for you.
Jorge, ¿me escuchas?
Sí.
Tenemos que hacerlo mañana. ¿Puedes hacerlo en la mañana a las 10 o a las 2? ¿Qué te conviene mejor?
Mañana.
A las 10 mejor.
A las 10.
Okay?
Sí.
Can we do it at 10, Judge? And I'm gonna have him come into my office, so if that doesn't work, then I can translate for him or something.
Right, that'd be helpful. Pat, will that work?
Yes, I'll add him on.
All right, we'll see you guys tomorrow morning at 10 o'clock.
Okay,
And
what about,
Pat, you want to give them, you're going to send them the sign-in information?
yes, yes. What about Joseph and Mr. Castañeda?
Try those right now and see if we can get the combo to work.
Mr. Sandoval and Mr. Garcia.
We're going to try and do them if we can get combo work.
Okay, Jorge, puede salir hasta mañana a las 10. Yo te voy a hablar.
Okay.
All right, Joseph, let's try and see if we can get the combo working on you guys. No, we're still have Spanish.
Yes, they're all Spanish.
We're trying to see if we can get a different person equipment to work.
Henry Castaneda, his.
Señor Castañeda, ¿puedes oír? No, he can't even hear me right
This
now.
lady still on that? Oh, no, I don't see her.
Señor Castañeda, ¿me puedes oír?
Sí, yo le escucho, sí.
Hold on. No, I have a feeling whatever is wrong is wrong. It may be with my computer because I don't know, but I'm doing everything that we normally do. So something is wrong with the Spanish interpretation.
Try to talk to Mr. Garcia in Mr. Sandoval's case, see if that.
Señor Garcia. Señor Garcia. I don't even think he has.
Judge, from a young person's perspective here, I think Henry Castaneda is on the English side and not the Spanish, because we can hear him speaking and he can hear Pat.
No, it's not working.
Okay, you can only play the cards you're dealt. You, Mr. Sandoval and Mr. Statson, and we got Mr. McCrum rescheduled already. We've got a 10 o'clock docket tomorrow and a 2 o'clock docket tomorrow, and if that doesn't work for you, we can just run it the next week if that's what we have to do.
Your Honor, tomorrow at 10 is fine. I'll check
For
with Mr.
Joanne's
Garcia.
client, let's just recall it tomorrow, 10 a.m. If that's a problem, I'll reach out to Pat beforehand.
That's fine. We'll just schedule everybody at 10 o'clock. I already have an interpreter coming in. I will inform them there'll be more, and maybe whatever gets fixed.
So Joseph, you need to tell Mr. Castaneda Bravo what we're doing, and Frank, you need to tell Mr. Garcia what you're doing because our interpreter can't communicate with him apparently.
Okay. Señor Castañeda, ¿me puedes oír?
I'm going to contact Joanne
Sí, le escucho.
to see if
Okay.
her
No
attorney
podemos
can translate
hacerlo
over the
ahorita
phone
porque
right now.
estamos teniendo problema con la interpretación. Vamos a tratar de hacerlo mañana a las 10. Okay?
Okay.
Okay. So, hables con tu abogado y ellos pueden explicar todo lo que estaba pasando. Okay?
Okay.
Okay.
Okay, can we still do in English Mr. Neville's case?
Yes, we can.
Glory be. Yes, please, thanks so much.
And Flavia, thank you.
Okay, this is cause 624-288. State of Texas versus Quattro Neville. This is a first amended motion to enter adjudication of guilt and revoke community supervision. Representing Mr. Neville's is Mr. David Christian. Representing the state, our Assistant Criminal District Attorneys, Guillermo Flores and Megan Galloway. Representing the Bexar County CSCD is Ms. Susan Gross, who I remind is still under oath. Mr. Neville and Mr. Christian, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearings by Video Conference that purports to have both your signatures on it. In fact, Mr. Neville, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Christian, as attorney for Mr. Neville, is this your signature on this document?
It is, Judge.
Thank you.
Yes.
The next document I'm looking at, Mr. Neville, is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document, Mr. Neville?
Yes, sir.
Thank you. And Mr. Christian, as attorney for Mr. Neville, is this also your signature on this document?
Yes, sir.
Mr. Christian, my understanding is that this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that accurate?
Yes, Your Honor.
Mr. Neville, in cause 624288 on the first amended motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
Yeah, sure.
Mr. Neville's, we discussed being true with an explanation. It's the alcohol violation that you self-admitted. It's the missing the mobile smart start, which you have the answer to.
Yes, sir.
And that's it.
Okay, so the defendant is entering a plea of true with an explanation. Is that accurate, Mr. Christian?
That's accurate, yes.
All right. Ms. Gross, would you please advise the court and the parties of the status of Mr. Neville's probation? Susan, your microphone is turned.
Sorry about that. He has been reporting as directed. We last saw him on July 12th of 2021. He has paid $258 towards his fees. He has a balance of $981 and he's current at this time. He's not completed any of his 48 hours of community service. He's had one positive for alcohol on the Smart Start mobile device, where he is currently testing at 4 times a day. That violation registered at 0.021. And additionally, he has missed 14 required tests in a period of 22 days. He's had one negative drug test, and he has completed the victim impact panel, and we have no proof of enrollment or completion of DWI education or the CATSNP programs. This is his first violation report, first MTR. He has no prior criminal history that we're aware of. And his officer is recommending that he obtain a scram device there while he is in Florida, and that he be allowed to report by mail in lieu of virtual reporting.
Is Mr. Neville's currently in Florida?
Yes, sir.
Judge.
Okay. And what does Mr. Neville's do in Florida?
I'm a cyber designer for the United States military and government.
Okay. Mr. Christian, what are your requests?
Judge, this one's an easy one compared to all the stuff I've heard you do today. So this gentleman originally signed up for VTC, but because he got transferred to Florida, they had to take him out of VTC. You might remember him, Judge. And so he self-reported to VTC the alcohol violation. And so that's how I believe this came about. And secondly, Judge, he's got his device under control now. The issue had to do with the charging. He's incredibly smart, way smarter than I am. But if it on a full charge, it was not working. And so now he has to do these little 15-minute charge, and now it works. So he's dealt with the company. He's wrote them letters. He's talked to them, and he's ultimately figured it out. So I think he's in a good spot. If you just deny the MTR and continue him, I think that's the ultimate. I think that he's in a good spot on that. Mr. Neville, does that sound right the way I described it? That you now know this machine is now working properly based on you fixing it with the company?
Yes, Judge. From what they said, and I do have the email where I submitted a thing to them on the missed test. Was what happened is when I plug it in and leave it and it fully charges, it overclocks. And so for some reason it goes into a charging mode. I do have a picture showing where it is saying it's charging, won't let me blow, and there's nothing is plugged into the device. What they told me was that you cannot continually charge it. So what I do is I wake up every morning for 15 minutes, I charge it daily instead of charging it all in one time. And I haven't had a problem, and I haven't had a missed test since then.
So Susan, were these 14 tests in a row because the machine didn't have a battery power to it, I guess?
No, Judge, I don't believe so. I believe that they were sporadic. Let me double check and I will pull up that report.
And Susan, while you're doing that, Judge, if I may, just briefly,
Yeah.
it looks as though that you had waived the community service hours because of his military service.
I'm
And
sure.
that's in the court summary. So I think that Susan might have just maybe missed that one little line that's in this big old document. And then two, I submitted to Susan. He did complete a class that I believe it's up to you to determine whether or not it is the right class. Susan, I think you uploaded it. It's an alcohol class, and I have an email where you said, let's run it by the judge, because he had to find a class in Florida. So he did do a class, and we're just hoping that it's something that you would allow to be.
Your Honor, it's the Air Force's Alcohol, Drug, and Prevention Treatment Program.
ADAPT-C, is that what it is?
Yes, sir.
So he has successfully completed that. So
As well as the education, sir.
and the DWI education he has completed and I sent it to Susan, so I'm hoping she got it.
I do have, on 2 dates, I can't say where it was not the machine. I was in orientation on the 21st and 22nd of June. So I have a missed test at 8 o'clock and at noon and at 6 o'clock. And those were when I can show you where I was, I work in a skiff and a secure confined facility. And so I cannot bring the device into the thing. And so I missed tests because I was in orientation.
Let me back up. Theoretically, you fixed the machine on or about July 13th, 2021. Does that sound right? That was the last day of skipped violation.
Yes, and I have a email. I sent it to Mr. Christian from the company where I submitted to them. They reached out to me and said, "Hey, this is what you need to do." The only other test I failed is when I was apprehended when I came to back to Texas and was arrested from the 12th to the 13th.
Mr. Nevels, have you been continuing to use the Smart Start mobile device after July 13th, 2021 to the present?
I continue to use the device, yes.
All right, Susan, have there been any violations from July 13th, 2021 to the present?
Judge, I'm pulling his record up right now.
And you currently have me testing, you had me testing 6 times a day, by the way, sir, not 4.
Judge, at the risk of talking too much, but this man came to San Antonio because he was told to report in person, and he was also going to take his sister to the hospital for a very significant treatment and diagnosis. He got arrested because he had this active warrant. So I know everyone, when they get arrested, they got a story to tell, but this gentleman has a very unique story, and it was a very tough situation. But he did make it back to Florida and is doing this, important work and stuff. So I know Mr. Nevels wants to talk about it at the appropriate time if you want to, Judge, but just know that he's been through the ringer on this deal.
Judge, in reviewing his account, I am showing skip tests both back in July, as well as mini skip tests between August 10th and August 13th.
I was in the Bexar County Jail at that time, ma'am.
And then also there was also, hang on. I'm having to pull all these up individually, so it's taking me a second.
But apparently there was an alcohol positive on the Smart Start August 1, 2021. Does that sound right?
Yes, that's the one I'm pulling up right now, Judge.
And it was very low. It was 0.021. Does that sound right?
It was 0.021. And that one didn't clear out, and okay, that occurred at 5:48, and it didn't clear out until right at 8 o'clock.
Mr. Nibbles, are you working in some sort of classified job position that has restrictions on what devices you can take into the building, that kind of stuff?
Yes, sir. I work in a, trying to think of the actual breakout. Secure, it's a skip, but I can't think of the actual breakout. But yes, I cannot bring electronic devices into the place where I work. Yes.
Do you have a security clearance level at some point?
I have a top secret clearance, sir.
Just basic TS, not
I have a top secret SCI.
SPI. Okay, now not compartmentalized, is that correct?
Yes, what's polygraph.
All right, I got you.
And Judge, if he's not gonna be, if he's gonna be in this skiff and not be able to comply, then it's definitely gonna be recommended that he go on to Scram.
So I have complied.
Go in the building with a Scram bracelet on, I don't imagine, if it's classified. Is that not true, Mr. Neville?
That is true, but ma'am, I have complied. I talked to them, and at the times that I have to test, I'm allowed to, it takes 15 minutes to get out there, but I'm allowed to go breathe into the machine. I haven't had a missed test since.
Okay.
All right, let me back up, guys. I apologize for interrupting, but before he missed 14 tests, did we have him on 6 blows a day because there was a violation somewhere?
Yes, Your Honor. I was originally in the VTC. When they told me I was out of the VTC, I had a going away, and I did have I did self-identify taking a drink on that day.
Hey, Josh, didn't we have a lot of problems with Mr. Neville's in Florida? I don't want to get him mixed up with anybody else in Florida. We had a lot of problems with somebody in Florida. Was that Mr. Neville's?
So Mr. Neville's came to the program. We were not aware that he was moving to Florida at the time. That is the reason that he came out. He just explained the only violation that we knew about before he was transferred over to probation was that alcohol violation that he just spoke about at his going away party.
All right.
And from April 26th until that day of June 14th, I had no problem, sir.
Okay, so as of right now, you're blowing 6 times a day in the machine?
Yes, sir.
All right. And Susan, did you determine, let's say for the month of August, how many misses, how many skips there were?
Hang on here. Let me go back and count. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. So it's the 14 that are alleged on the Smart Start mobile, or I mean on the MTR, and those occurred between August 10th and August 13th. And then he's had 2 additional skips since then on August 17th and August 26th.
All right, you got me totally confused because the allegations on the MTR is there were 14 skip tests between June 21st and July 13th, 2021. I want to know what's happened between July 13th and today on Mr. Neville and the Smart Start mobile.
All right, since July 13th, there have been 15 skip tests.
And from the 10th to the 13th, I was in.
Options here. You got any ideas?
Sir, from the 10th
Yes.
to the 13th, I was in jail.
Smart Start's not working for Mr. Neville's because he's not blowing into it for whatever
Mr.
reason.
Christian,
Judge, if I may, if you could listen from the 10th through the 13th, go ahead, Mr. Nevels.
I was in Bexar County jail. I was arrested, sir, when I came back to report.
Yeah, but this is since July 13th. So
No,
the
August, sir, Your Honor, August, when I came to San Antonio to report, and I was arrested in August 10th. So that time she's saying that I missed those tests, I was actually in Bexar County.
All right. What date did you go into Bexar County? What date did you come out of Bexar County?
Judge, I'm looking it up right now. He was arrested August 11th at 5:39 p.m. and he was released August 12th at 10:15 p.m.
And so, Judge, if I may, having to do this all the time, those dates about release doesn't mean that's when you're walking out. Just throwing that out there.
Well,
Correct,
even
sir.
if we say from 8:10 to 8:13, you know, giving him the benefit of the doubt, there's still been misses from 8:13 till today, is what Susan is telling me. Susan, is that accurate?
Yes, there was a violation, let's see, on the, I got so many things open right now. Hang on here. August 17th, and then on August 26th, There was also a violation, and hang on, it's coming up. And that's when he had the high BRAC, which was 0.021.
And that was on what date?
That was on the 20, it's the one alleged in the motion. Hang on.
That was August 5th. Not August 1st.
The one that in the motion said August 1st,
It was
2020.
August 1st.
Yes.
So Judge, what I'm asking, oh, go ahead.
Mr. Neville, I apologize. You just told me this. Tell me again. Exactly, and maybe some things you can't tell me. Exactly what is your job position that you have to have such a high security clearance and all that?
I'm an ethical hacker, sir.
You're a what now?
An ethical hacker.
What is that?
Without going into detail, I go into other countries' computers and make sure that they don't mess with our systems.
Okay. So is the building you work in Florida one of those that, for instance, if I try to go to Special Forces Command and I want to take a radio with me, they won't let you in with it. I don't even think you can take a cell phone in, nothing, that kind of deal.
You're not allowed to take.
The environment you're in when you're working?
Correct. It's a top secret environment. I have to badge in and badge into to get into the building and badge into just to get into the facility.
All right, Dave. Scram is the obvious answer, but he can't use Scram because he can't get in the building with an ankle bracelet electronic device on. So here's the plan. If Mr. Neville thinks he can clean up his act and start blowing in the damn machine, we're just going to start over again. And if there are any more problems, I'm just going to put him in jail. I'm tired of this. It's just, you know, I understand the battery thing, but you fixed the battery thing and you're still not blowing in the machine. You have a 2-hour window for each blow and you're not blowing in the machine. Explain that to me.
Sir, I don't know where she's since August, since the arrest, I have not missed tests at all. So that's what I'm trying to figure out. Where are these missed tests coming from? And I was in jail in those times for all those, the 13 or 14 tests. I was in jail, so I couldn't have blown in the machine.
Yeah, Judge. So I get it. We don't have the benefit of seeing it, and I've talked a lot with him, so I didn't know that was going to be an issue. So I like your plan. Let's just start over with them, Mr. Nevels. You got the machine down. Don't mess it up. Is where I think we're at, Judge.
Susan, can we give him weekly UAs in Florida?
Being that he's not supervised there, he would have to go to a lab, pay for it, and find a way to ship it to his officer.
State recommendation. Let's get Mr. Nevels out of here. He's got better things to do. Mr. Christian does it. Mr. Nevels does. I understand. State, what's your recommendation, please?
We can't hear you.
I was Ms. Galloway's case, Judge. We Ms. Galloway, we can't hear you. She says, Judge, via chat that the state agrees with the court's recommendation.
All right. Mr. Neville, in cause 624-288, the court accepts your plea of true with an explanation. I deny the state's motion to revoke your deferred adjudication probation or to continue on deferred adjudication probation with all prior requirements and no sanction at this time. Altering in many conditions, let's reduce the Smart Start Mobile back to 4 times a day. That'll make it easier on him blowing 4 times instead of 6 times a day. And then I'm requiring substantial compliance in all other areas. If there are any classes or anything you haven't registered for, you need to immediately get that done. So within 30 days, he needs to be registered for whatever other classes he hasn't done, or he doesn't have community service. So that should be all we need to do. But Mr. Nevels, you're going to have to figure out your timing on making sure you don't miss any more blows.
Yes, sir.
I love you like a brother, but business is business. You got to blow on the damn machine.
Yes, sir.
All right. Anything further from the state of the defense on Mr. Nevels?
No, sir.
No, Judge.
Can we blame Afghanistan on Mr. Nevels because he works for the government?
I think Susan's gonna say something. Susan, don't say anything if it's gonna hurt me.
Hey, when I left Afghanistan, we were winning. I don't know what they screwed up at all.
Mr. Nevels,
Susan.
ma'am.
within the next 24 hours, you'll be receiving documents from your officer. You need to sign those and return them back. It's your amended conditions showing that you've been reduced to 4 times a day. That's probably not gonna happen until tomorrow, being that it's already after 5 o'clock here. So get with your officer tomorrow and they'll be sending you the documents, sign them, send them back, and then they're gonna change your blow times, okay?
Yes, ma'am.
And as far as the CATSNP program, you might want to call CATS because they were still doing CATSNP online, I believe.
Yes, ma'am.
And so you may be able to do it via Zoom. And any other questions?
Susan, while we have you here, can you ask the judge if that class that he submitted is enough? Because it's the Florida equivalent. Is that enough?
Well, you already brought it up. That's up to the judge. Judge, do you want to give him credit for CATSNP for that Air Force drug and alcohol thing you went through?
When did you go to the Air Force course?
March
That was
23rd.
yes.
I'm sorry, when?
March 23rd
What year?
This
of
year,
this
sir.
year. I have a letter.
Your Honor, I spoke to you back in March because the case was taken. This was September of 2019 when this happened, and it affected my commission as well as my rank. And so you said I need to do all these things. You put me on the Smart device on April 26th, and I had to go to the court, to the Air Force, and say, hey, this is a class that I would take. So I was being proactive at the time and went to the class.
I think if we weren't still drinking, that would probably be okay. But since we have a positive route call since then, do we not, Susan?
Yes.
That's your punishment for not blowing in my machine. You got to take an outpatient drug course. So consider
Yes,
yourself
sir.
punished. I can't punish Mr. Christian any worse than keep him away from happy hour for as long as possible.
Hey, at least he gets to leave and go. We're stuck here for a while.
You got any questions, Mr. Devils?
I still would like to speak to you, sir. I don't know how to do that. I did talk to Miss Benavidez, and she said I'd have to go through my lawyer to talk to you.
Dave, do you want to go in a breakout room with Mr. Nevels and make sure he's got any questions he's got answered?
Yes.
I think he's requesting to talk to you.
Oh,
yes.
Now? Sure, go ahead.
I'm guessing at a different time, but I guess I'd have to go through my lawyer. I guess I don't know how that works. I know you said
Wants a
you said at some point that
conversation.
I could talk to you. I could reach out to you because this whole thing has been frustrating. I think that's I would like to talk to you individually.
You can't talk to me individually. We got to have DAs and defense counsel present. It's one of those lawyer things.
How about this, Mr. Devils? Let's me and you talk offline. Let's get done with the Zoom, and then you tell me what you want to do. Maybe I can propose it to everybody. We'll work on something.
Okay, that'll work.
Thank you, sir.
All right. Good luck. Thanks for your service, sir.
Okay, we still have Miss Flores here. We're not finished with her?
If it'll work, we'll stay here till the cows come home. Well, we got to do and it'll work. That's great. Who else we have?
Miss Flores.
Judge.
Oh, that's right. We took a break. Hang on. Let me find it.
Okay, Mr. Nobles, you can take off, I believe.
Okay.
Thank you, sir.
Was Mr. Neville's Air Force, I'm guessing?
Yes.
Yes.
He's, I think, 39 years old and
Still
been in
drinking.
a long-
Okay, Caroline Flores, where were we on this one? 6'3".
Judge, you had let us go in a breakout room so we can have a discussion. We've had that discussion. I still, you know me, I still have one last request. You had said either 180 days or scram or Myoff. You were giving her a break.
Myoff.
Sadaf. Yeah, Sadaf. I'm sorry. Myoff or Sadaf and 100 or 180 days. Judge, I would, and we're going to go with the jail time, Your Honor. I have her dad here, and we have a plan on getting her some treatment. It's mostly mental health treatment, but it's also substance abuse treatment. Judge, so my request is that you revoke her probation, sentence her. My one request to you is, because she's paid in full, because she's done her classes, because she's been on your probation for a while, if you would consider altering or reforming the judgment to sometime less than 180 days.
Here's my problem. All the evidence in this case indicates she's a methamphetamine addict. And the textbook solution is to get them to rehab and try to change the way they think about using drugs. I can't do that. So the only other thing I can do is keep her away from methamphetamine as long as the law allows, and that's what we're doing. So I appreciate your argument, and I understand Ms. Flores' concern, but the longer she's out without intensive supervision, the more she's going to use drugs. It's the way it is.
Yes, sir. I understand.
All right, Ms. Flores, in cause 633156, court accepts your plea of true. I grant the state's motion. What are we dealing with? To revoke your community supervision. I sentence you to 6 months in the Bexar County Jail. It says a $500 fine plus court costs, credit for time served, time and money to run concurrent. I hear rumors there are drug alcohol rehab programs available in jail. I don't know that for a fact they exist. If you can find one and you can prove to me that she's going to these in jail drug alcohol things, then I'll reconsider what we're doing, because then she's showing some personal initiative and moving in the right direction. But Judge, by the time she gets out, if her parents are interested in helping her, she'll be clean from any drugs by the time she gets out, and that's the time to get her into some program somewhere. Any kind of inpatient program, which is what she really needs, according to Ms. Gross and Ms. Benavides and all those guys that have been probation supervisors for 20 years, it is going to cost way too much in the real world. Like $3,000 a day or something. I don't know. It costs incredible amounts of money to do all that stuff.
Yes, sir. No, we appreciate the option, Judge, and she is scheduled for for classes in the jail. But these folks, they have a private health insurance. They're going to be able to get her to her. But we understand the 180 days.
All right. Best of luck. Good luck, Ms. Flores.
Thank you, sir.
You bet.
Your Honor.
The attorney Alfonso Bavides is back. I don't know if he needs to talk to you.
Okay.
I do, Your Honor. I wanted to see if, I kind of had a little freeze earlier today. It's my first time doing a criminal defense hearing. And, I wanted to see if you would reconsider the punishment for my client for something other than jail. He's been working for a company for 5 years now, and he's worried about losing his job if he has to go to jail for that much time. He's a breadwinner of his house. Anything other than going to jail, no matter how severe it is, reinstating his conditions, but just allow him to keep maintaining his job, his position, and to be able to feed his family.
He was AWOL. We haven't seen him in what? Years, months? How long has it been?
11 years. 11
years?
Your Honor.
How do you mitigate that?
He was 21 years old. He was young. I've been on the other side. I was
21, but I didn't do that.
I did worse than that, Your Honor, and here I am.
They didn't catch you. That's the whole thing. That you were lucky, like all of us probably.
I wasn't lucky. I was actually charged with the DWI myself when I was 21 years old. I'm an alcoholic in recovery. I go to my LCL meetings. So I've been on the other side of the fence. And I can tell you, for somebody that hasn't done anything in 10 years, that this is not a habitual criminal. If there's somebody that's
once again, he hasn't done anything that he got caught for in 10 years. I'll go along with that.
Well, that's a fair assumption, but I mean, if in 10 years not getting caught for, if you're a habitual criminal, I mean, you'd have to have a pretty good streak of not getting caught.
All right, Mr. Benavides, love you like a brother, but business is business. I made my ruling. I'm not going to change it. In my opinion, that's what he deserves. I understand in your opinion, it may be different. In the state's opinion, it may be different. But that's the way it is. So in the future, I would appreciate it if you wouldn't come back and try to get me to rethink these things, because unless you've got new evidence, I'm not going to do it.
Understood, Your Honor.
So thank you for, doing your best for your client. We all appreciate that. But you can't change the fact.